Welcome to the second day of our online seminar researching discrimination in online advertising and e-commerce. For those who did not participate yesterday, my name is Caroline Kaufmann and I am one of the co-hosts of this seminar. We had a wonderful first day yesterday with inspiring presentations and animated Q&A sessions. A number of those presentations we had yesterday took a more legal approach, and other presentations focused on the computer science element of researching online discrimination. The first legal presentation was given by Professor Janneke Gerards and Professor Frederik Zuiderveen-Borgesius, and they gave us their view on how an anti-discrimination law should look in order to deal best with online and in particular algorithmic discrimination. And their opinion was that we should choose for a hybrid system, something between a closed system and an open system, and choose for a list of protected grounds, but add to that an open category in order to make it possible to also act against discrimination on other grounds than those listed in the legislation. Professor Miklitz dealt with personalized advertising from a consumer law perspective. And in his opinion, it is best not to focus on protected grounds of vulnerability, but to treat personalized advertising as just one of the unfair commercial practices that are used by online traders, online advertisers. And his suggestion to improve legal protection for consumers is to shift the burden of proof. Normally, it is the consumer who complains about an unfair commercial practice who bears the burden of proof that the practice was indeed unfair. And his suggestion is to shift this burden of proof to the trader. So this comes down to a presumption that commercial practices are unfair, and it is then up to the trader to prove that his particular commercial practice was fair. And then we had Professor Annemarie Haagstian, who talked about the link between online discrimination and discrimination in the real world, using the example of Airbnb. Airbnb had the policy of posting pictures of hosts offering accommodation, but this led to discrimination in the sense that people with certain protected characteristics were more often refused. They received a message that the accommodation was not available, while people without the protected characteristic received a message that the same accommodation was still available. So then a shift was made in the policy, and it was possible to advertise accommodation or advertise that you are looking for accommodation without showing a picture. This removed this possibility of being refused based on a picture, but it entails the risk that afterwards, when you received a notice that you could stay with a certain person, and then you showed up and people noticed that you did have a characteristic corresponding to a protected ground, you were refused in anyhow, so that you had traveled miles and miles to just find out that you couldn't stay in the accommodation that was promised to you and you actually already had contracted for. I will then pass on the floor, or better the screen perhaps, to my co-host Pedro Hernandez Serrano to discuss the computer science presentations of our first day.
Yeah, thank you so much, Caroline. Yeah, in fact, yesterday was a great day. We had a lot of new insights and very nice discussions and engagement on the participants. And in fact, many methodological challenges in auditing algorithms were discussed. So for example, Professor Hacker discussed an important point. So when you try to moderate differential treatment, either in the pre-processing data part or the post-processing outcomes of the algorithms, you have to actually decide whether you are in the side of protecting group fairness or protecting individual fairness, right? And this can be tricky, even in the if you're talking in the pre-processing part. So you are basically saying which data points you are allowed to collect or not. And if it's in the post-processing part, here's the challenge, of course, that it's manually impossible to audit signs of discrimination on every outcome of, for example, in a candidate selection process, right? So if you're going to do that manually, why do you need machine learning, first of all? So fortunately for us, one of the talks today will try to address these issues using NLP. Do we need to actually improve then the technologies for annotation? So, and also some of the questions were, does the government should actually invest on this, on annotation frameworks, right? But it still remains the challenge of data curation and labeling and a greater scale, right? And moreover, Professor Wanagoga, she presented a study where volunteers would annotate ads, but a greater conclusion here in crowdsourcing in general is that people were not having consensus on what was a political ad or not, and this comes down also with fake news and fact checking type of things. It's very subjective. So, or like in Professor Juana's presentation, she mentioned that 50% of the cases, people were actually not having consensus. So that's really a chance, basically. So shall we then advance policies for creating more reliable and transparent data annotation? So, of course, in an ideal world, the Facebook ad library that would contain all the ads, for example. Same goes for Google. There is not yet regulation that actually advances that, but still they are the biggest actors taking about online advertisement. And these, we might address this in an antitrust and competition point of view. Actually, Anne-Marie mentioned the concept of power responsibility equilibrium, where the biggest market chunk, the more responsible the company should be. So it will be interesting to see if there are studies about sentiment of online advertisers. Moreover, Professor Cristo presented a fascinating study on algorithmic pricing inside Amazon, comparing sellers' behavior, where normally Amazon, also a seller, led the market price for products, and the rest have algorithmically colluded to this behavior. That's fascinating. So looking forward for the next talk addressing actually the legal point of view of algorithmic pricing. Catalina, I will give you the microphone. Thank you very much.
Thank you so much, Pedro and Caroline, for this wonderful summary of what happened yesterday during this wonderful conference. It is my pleasure to welcome you all, the audience and also the speakers once more to the second day of the conference that brings together discrimination from a individual, a citizen, but also a consumer perspective. And today we have the same spirit that Pedro and Caroline emphasized from yesterday's opening day. We are trying to preserve that by bringing together together scholarship, not only from law, but also from computer science. So hopefully we are going to have a very nice inter and multidisciplinary discussion after some of these presentations, and perhaps also towards the end of the session today. In the first panel, which is going to include the next 4 presentations, I have the pleasure of welcoming some scholars who are very, very vastly covering topics such as press discrimination, but also hate speech. And I hope that in the conversations that will happen in the chat and also in the vocal conversations we will be having, that we are going to try to bridge these different practices of discrimination and really ask ourselves the questions: what can we learn from the perspective of the research agenda that Caroline and Petra presented yesterday? What can we learn about how to prevent discrimination in advertising and online shopping? I have the pleasure of introducing, therefore, the first speaker, who is Qian Li. She is a PhD candidate at the Faculty of Law at Maastricht University, and she's currently doing her research under the supervision of Caroline and also our colleague Niels Philipson, who I believe is also in the audience here today. Qian, the floor is yours, and you can share your screen if you want, or you can just proceed. Thank you.
Thank you very much. It's my honor to present here. Then I will share my screen and the topic of my presentation is how should competition law respond to AI-enabled press discrimination from the perspective of China? And I will focus on 3 questions. What is AI-enabled press discrimination? Why does it draw competition concerns? And how should Chinese competition law respond to this challenge? Let's start from a report in March 2018. It was the first time that AI-enabled press discrimination, the so-called 瞎数 through big data in China, was introduced to the public by the mainstream media. In the first case, a taxi hailing app, Didi Taxi, offered different prices to passengers who simultaneously called for the same type of taxi from the same place of departure to destination. However, the passenger called by Apple device was charged higher than the one by Android device. Another similar case is that the loyal customer was charged more than a new customer when they ordered the hotel room on the same website at the precise same time. As we can see, the rapid growth of computing power and the expansion of internet access enabled the business models based on collection and perception of big data. As such, it has become technologically possible for the undertakings to offer customers different prices for the same goods at precisely the same time. This technique, in my context, is called AI-enabled press discrimination. In economics, price discrimination are referring to charge different prices to different customers. Economists categorize it into 3 degrees. In the hypothetical scenario of the first degree discrimination, the undertakings charge each customer according to his or her willingness to pay. In the second and the third degree discrimination, the undertakings charge prices charge different prices by volume or for different categories based on the characteristics. For any type of price discrimination to occur, it requires a downward sloping demand curve, a way to identify a customer's willingness to pay and barriers to take advantage of price differences from different groups of customers. In digital markets, the demand curve are still assumed to be downward sloping, since the customers are still willing to buy larger quantity of goods when the prices are low. However, equipped with big data and algorithm, the undertaking can more precisely estimate the customer's willingness to pay based on the poetry shopping experience of customers. Further, the barriers to Online shoppers are neither universal nor transparent because the online shoppers only see the personalized digital shopfront offered to them. Therefore, the barriers to take arbitrage tends to be intensified. In this regard, AI-enabled price discrimination is approaching to be the first degree discrimination, which maximizes the output of undertakings and but at the expense of consumer surplus. Then it leads to the second question. Why does it draw competition concerns? Normally, it is good for the economy. It allows undertakings to provide customized products and services to different customers, which leads to the positive gains to both consumers and businesses. However, it also triggers competition concerns. One issue is that it may impede effective competition once big giants abuse their dominance in digital markets. The stronger the market power, the stronger the possibilities to hinder market access by potential competitors, which may thereby impede effective competition. By 2019, there were 193 platforms with a market value of more than $1 billion in different economic fields in China. The size of Chinese digital economy in 2019 has reached 35.8 trillion RMB, which takes 36.2% of the GDP in China. It reminds us to be alert of the anti-competitive effect brought by AI-enabled price discrimination in digital markets. Another concern is that it may do harm to customers. It may not only directly exploit customers, but also exploit intermediate customers in upstream markets and create a distortionary effect that harm customers in downstream markets. By March 2018, amounts of articles about xiaxu through big data were posted on the different social medias, involves many internet undertakings. The top three are Didi Taxi, Amazon, and Alipay. The involved internet undertakings are generally in the fields of online shopping, taxi, hailing, and takeout food, which occupies an important position in people's daily life. A survey of 2008 people shows that more than 50% of them experienced the xiaxu through big data, the universal phenomenon due to the information asymmetry and the call for the regulation. Let's see who they are representing, the Chinese netizens. The population of Chinese netizens reached 989 million, which takes 1/5 of the world, with 782 million online shopping users in China by December 2020. It indicates the highly potential risk of consumer interest brought by AI-enabled price discrimination in digital markets. Since the protection of fair competition and the consumer interest are the objectives of Chinese competition law, it makes sense to consider, among others, competition law intervention. Then we come to the third question. How should Chinese competition law respond to this challenge? In China, price discrimination is specifically mentioned as an abuse of dominance, where undertakings apply discriminatory prices to trading parties under equivalent conditions, and it will fall into the scope of anti-monopoly law. Here are the three conditions to determine price discrimination under Chinese competition law. The first condition is undertakings holding a dominant market position. Dominance exists in a relevant market. That's why we normally start from the market definition. A dominance refers to a market position held by undertakings that are able to control the price or quantity of products in the relevant market, or to hinder market access by potential competitors into the relevant market. listed are the factors to be considered when defining dominance. The second condition is that the undertakings apply discriminatory prices to the trading parties under equivalent conditions. The recently published guideline on the platform economy further specify its application based on big data and algorithm, and in accordance with the payment capacity, consumption preference, and the usage habits of the trading parties. With regard to the equivalent, it means the trading parties that have no differences that substantially affect the transaction between the trading parties in terms of factors like transaction cost, transaction security, scales and the capacity, credit status, and so on and so forth. It is noteworthy that the differences in privacy information, transaction history, individual preference, and the consumption habits of the trading parties obtained by the platform during the transaction do not affect the determination of equivalent conditions. The third condition is to say whether there is any justification. If the conduct is based on based on the need of the trading parties and in compliance with the justified industry practice, or it is a preferential promotion offers for the first transaction of the newcomers within a reasonable period of time. The recent guideline also offers another choice, which is random trading based on fair, reasonable, and non-discriminatory rules of the platform. By so far, there are 3 administrative penalties given by the competent authority based on discriminatory treatment in franchising sectors in China. Let's see a typical case. Xuzhou Tobacco Company, Pizhou branch, was fined for abuse of dominance by means of discriminatory treatment in 2014. Firstly, it has a dominant market position in Pizhou tobacco wholesale market. Since Xuzhou Tobacco Company was the only undertaking with the monopoly license of in the local cigarette wholesale market in Pizhou City. Secondly, it applied discriminatory treatment to the trading parties under equivalent conditions. 3 branches of Jinying Company and the 2 branches of Huanlemei Company were all direct to consumer retailer and were clarified as KA type of customers. They all signed the same type of agreement with same text and assumed the same rights and obligations. But Xuzhou Tobacco treated branches of Jinying Company more favorably with regard to the frequency to order the cigarettes and the quantity of the most popular cigarette distributed through the online ordering system. Thirdly, there was no justification. On the one hand, the claim clarification standard of the tobacco industry could not justify the discrimination, even if it is reasonable. Xuzhou Tobacco also didn't treat the retailers equally within the same category. On the other hand, the claimed a strong capability and the large sales volume of cigarettes of Jinying Company also couldn't justify this behavior because it was due to Xuzhou Tobacco's supply preference. So this case provides us how the competent authority assess price discrimination in practice. Then we come to the conclusion. Although there's no established case on AI-enabled price discrimination so far, the competition law and policy tends to be active to respond to the challenges in the digital markets since 2020. Last but not least, the current legal regime to assess price discrimination still applies in the digital market and can to provide some inspirations to other jurisdictions. Thank you very much for your attention.
Thank you very much to you as well, Tian. It was very interesting to start with competition law and to have a look at what price discrimination looks like from the competition law perspective. And now, before we move to the next speaker, who I'm actually really very happy to finally meet, because I have been seeing him everywhere on social media. So hi, Fabrizio, very nice to finally meet you screen to screen. I would like to say that we are going to have a discussion, a very, very generous time for discussion will be allocated after Fabrizio's presentation. And I would like to kindly ask everyone in the audience to write down their questions in the chat, and also when time comes, just express their willingness to have their ideas presented and their questions posed to the speakers by way of raising their hand. The button is under reactions, can be found under reactions. So with no further ado, let me introduce you to Fabrizio Esposito, who is assistant professor in private law at the Nova School of Law, and he's also a member of the Nova Consumer Lab, which is a really innovative consumer lab from what I have also been able to see on social media. And he also coordinates the Meta Law and Economics Network. So Fabrizio, the floor is yours.
Rookie mistake. So thank you, Catalina, for this really, really warm introduction. I hope I will be able to live up to the expectations that you have generated in the audience. I would like also to take this as an opportunity to emphasize that the great success of the Consumer Lab is due mainly to George Moraes Carvalho, who was here yesterday, I believe, who is being able to attract a significant number of students who remained involved in the project even after they graduated. So it is thanks to him and to them that the Consumer Lab at Nova is working so well. Now, moving on to the topic, I want to talk about price personalization, which was the subject of the previous presentation and came up during several talks yesterday already, from the perspective of EU law, focusing specifically on the possible interpretation of the new information requirement that has been introduced by the Modernization Directive. So, in the spirit of this conference, let's rock. So what I want to, so my presentation can be roughly divided in the following points. The plain meaning of the provisions of the provision on this information requirement and its problems, how we can use the interpretive tools that are accepted by the Court of Justice to try to add a little bit of color to this plain provision, to this plain meaning, focusing in particular on the perspective of a trader who is faced with that provision, which I think it's quite important to understand what is actually going on. And finally, there are some additional considerations that might be relevant to, probably you might be having in the back of your mind while I'm talking, and I will try to address them from the beginning. So the provision says, where applicable, consumers have the right to know that the price was personalized on the basis of automated decision making. This is a provision that is included in the Consumer Rights Directive, so it is a maximum harmonization provision, which is already a doctrinal problem because we have a directive on price indication, the price indication directive, that is instead a minimum harmonization directive, and had this provision being added there, then member states would have been it would have been easier for member states to keep reflecting on how to deal with price personalization, which, as we have already perceived during this conference, is complicated and concerning practice. Now, I think that it is the case that if you read this provision, what you can expect consumer to having received is the right to know that the price was personalized. So if the trader tells you, look, this price was personalized on the base, was calculated on the basis of your profile, on your purchasing history, and so on and so forth, this should be sufficient to comply with this plain meaning. And this is also the way in which I have seen the provision being understood in the discussions by EU scholars that came out after this provision was started circulating. And it is also the case, I think, that this is what had been implicitly assumed to be the content of a possible information requirement in the policy discussions that came before the publication of the proposal of this amendment. The paper by Burke, the paper by the OECD, and in other contexts, there was a discussion of transparency of price personalization that seemed to be focused on the fact that the information that needed to be transparent was that the price was personalized. So it seems that we have received what the discussion has suggested. But I would like to say that I'm not particularly, I would like to emphasize some problems with these state of the art. So to see that, let me show you. So this is this slide includes something that was so this was a screen that was part of one of the behavioral experiments that you can find in the personalization study by the European Commission. And this was presented as a high transparency setting. And what you can see is that what is actually being disclosed to the consumer is simply that the price is based on your recent purchases. You do not have further information. And for in that study, this was perceived as a high level of transparency. Now, that study shows that this transparency did not have particular impact on the behavior of consumers. But there is a more recent study that was published by the OECD in late January, if I'm not wrong. And here, again, we have more transparency because the consumer is informed that the price could be higher or lower. Then we can discuss whether these sentence here, we use your personal data and calculating this price for you, is enough to comply with the information requirement, because maybe it is not saying that it is based on profiling, but nevertheless, in terms of with regard to the core information, this is yet more transparent than the previous one, because you have this idea that they are at least informing you that the price might be maybe higher or lower. Now, I would like to ask you, what do you think? Do you think that the price was higher or lower? So you can do that by using this QR code. My chat has disappeared.
You can just go to the top of your screen, and then if you hover, then you will find the chat there.
Yeah, I know, I'm doing that, but still the chat is not appearing. So Perhaps, Laura, I'm going to send the link to you via email, and then you can share it with everyone.
Laura's is perfect in the chat.
Hold on. Laura. This is exactly the kind of thing that you would not want to happen.
But maybe what we can do, because I already voted actually, so maybe what we can do is if someone has their phone next to themselves, then you can just also scan the QR code with your phone. So, and if you don't have your phone there, then you can also just use the link that Laura is going to share. Fabrizio, maybe that can also help.
Yeah, no, the additional problem was that I was not finding Laura's email, but now it's here. So apologies, many apologies for this, but I think it is useful to reflect a little bit more. So I'm gonna give you, what, 1 minute?
That's perfect. The link has been posted in the chat, so. Now I'm very curious about the answers.
Thirty seconds. All right, so let me share the results. So now, do you see the results?
Yes.
Okay, so you are a sophisticated audience, I would say, because the majority of you concluded that it was likely to be the price is likely to be higher. Some of you thought, nevertheless, that the price could be lower, and 25%, more than 25%, had no clue, or was at least unsure. So now let me go back to the presentation. So here is the thing. In this particular study, the same information was given when both the price was actually higher and when the price was actually lower. And this is something that we really need to reflect about in terms of research design, because as I will explain in a minute more in detail, this does not really make much of a sense from the perspective of the trader. And yet, this is the kind of assumption that we find when in these kind of studies, when they are trying to understand this. And this fact does not allow us to evaluate the very critical information, which is what are consumers going to get from the simple information that the price might have been increased or reduced, or worse, when the trader tells you the price is appropriate or adequate for you, right? So the study by Van Boom and others is quite interesting in this regard, because it is the only study that I have found. But if you know others, please write them in the chat, because when I'm gonna end giving the presentation, I will be able to access it, hopefully. They find that telling you that the price is adequate to you, contrary to what this sophisticated audience has perceived as problematic, actually increases the propensity to purchase. The willingness to enter into the transaction by consumers is actually increased. Also, I have been working with one of the students of the Nova Consumer Lab on a survey that for the moment has about 350 answers. It is in Portuguese. I'm not going to share it with this audience unless somebody would like to answer, and then I'm happy. I will be happy to do that. And here you can see that there is a part of the population of those who have answered that again have no idea. There is a minority that understood that the price has been increased. A significant number, 1/3, that suspects that this is the case. Another significant segment is unsure, and a minority thinks that it is more likely that the price was reduced. Now, of course, there is a very significant limitation in trying to understand consumer perceptions through this kind of surveys rather than with behavioral experiments, which comes from the fact that with the survey, you are basically suggesting the answers. So you are asking the respondents to activate their critical thinking in ways that normally do not happen in online trading, which is oftentimes designed to do exactly the opposite, to make it as simple as possible for you, also in ways that are to some extent manipulative, as we have discussed yesterday. So there are two problems here that I think have not been taken enough into consideration. The first is that traders who are going to apply discount have a very strong incentive to tell you that that is the case. And this is something that we can import from the economic literature on quality signals in general. Right, so you want to signal that the price is more convenient for this particular consumer, and therefore you're going to offer a lower price. But then there is also a problem of manipulation when you start dealing with this kind of practices, which has not been studied because the prices are always the fact that there is a discount is hidden in these studies. Because by showing that there is a higher price and the consumer is being offered a discount, then you can rely on behavioral phenomena like anchoring effect in order to increase the propensity to buy, because you make the purchase appear more appealing than what it actually is, especially if you instrumentally increase the list price in order to because then you know that you are going to offer the lower price to essentially everybody, and this has not been studied. Now, the point seems to me to be that if this is the situation that we're actually dealing with, simply informing the consumers that the price was personalized is not going to be particularly helpful. And now the task becomes to take this insight and turn it into legal arguments that can be used in front of the Court of Justice, possibly. And this is not such a difficult task, because we know that the Court of Justice likes to declare that it is willing to accept argumentative schemes that essentially take into account anything that you can possibly think of: the objectives, the context, EU law as a whole, and also the origins of the provision. So there is a very rich canvas that you can use to bring brightness to this plain meaning. So what are the alternatives on the table? The alternative on the table, the first is the plain meaning, so the price was personalized. Then the provision that the norm that I prefer is the right to know also the impersonal price. So you should be informed what the impersonal price is, and at the same time what the personalized price is. Iconically, this can work very simply because you can just put one next to the other and use flashing colors in order to make it clear which one is the one that is actually going to be applied. And then also based on the discussion that we had yesterday about meaningful information about how the algorithm works, we might also consider a right to an explanation declined in some ways. Now, let me begin by claiming that this third provision this third option should be ruled out immediately. And there is an argument from the origin of this provision, because the original version of this information requirement was the one that you can see here on the top. And this provision pretty much wanted to go in the direction of giving meaningful information. And I think this then would have been clearly interpreted within the general context of this kind of information requirements as it is discussed in the context of the GDPR. But it is clear that the legislator has settled for something that does not go in the direction of of giving to consumers information about the algorithm, but giving information about the price. So the focus is on the outcome rather than on the process. Now, the objectives, the aims of a provision like this should be quite easy to identify, in the sense that we are primarily concerned with protecting the economic interest of consumers. Then, of course, we can we know that we should take into consideration problems of discrimination, but this is not a provision that has been designed to do that. We have other branches of the legal system, as we discussed yesterday already, that should intervene for that. And this is an information requirement, so it should give to consumers the tools that they need in order to be able to protect their economic interests themselves. Now, a tricky aspect of this information requirement is the fact that if you read the recital that complements it, the recital speaks about the need to empower consumers about the potential risks of price personalization. And this is a little bit tricky. I was a bit perplexed, and I am still perplexed, I have to admit, because
could we maybe just have 2 more minutes to conclude, and then we can also deal with the perplexions in the discussion, because that's a lot of food for thought indeed.
I am finishing. So we're not dealing with potential risks at the moment in which the offer is formulated and the profiling has been used in order to offer the personalized price. We are not anymore at the stage of a potential risk. We are at a very concrete stage where the risk has manifested itself either in the form of a surcharge that is opaque, right? Like in the examples that Shanling has given in her slides at the beginning, or a manipulative discount. So you increase the reference price in order to then manipulate consumer preferences by playing with the discounts. But traders will have an incentive to show that they're offering discounts. So when they're doing that. So it is quite unlikely that we are going to see provisions like that we're actually going to see in practice information disclosures like the one that have been tested empirically. So these are additional considerations that could be discussed. But my conclusion is that the plain meaning is likely to be very uninformative for large part of the consumer populations, or although these needs to be empirically tested more, then we do not have enough information in this regard. There is also an interesting policy issue regarding who is the average consumer that you should be referring to. For example, I think that it should be the targeted consumer, meaning in this context, the consumer that doesn't get it, right? So, and in this context, this provision is also based on a description of what the objective should be, protecting against potential risks, that overall shows that this provision was really the result of a political compromise based on ideas that were not particularly clear. So I think this is really a ground for courageous interpretive moves by the Court of Justice with the support of the academic community. And I think that already an improvement would be to recognize this right to know also the impersonal price, with the proviso that we might need further rights, for example, a right to opt out. But this is not something that you can, I find, within the provision that we currently have. So apologies for taking more than the allocated time.
No worries. Thank you so very much. These were fascinating points. And this is a very, very nice kind of sway into the discussion. Thank you very much, Fabrizio, and thank you very, very much once more, Tian, as well. So perhaps now we can just open the floor for discussion. So we had some competition law, we had some behavioral consumer protection from Fabrizio. So I thought I saw in the chat that already Frederick, welcome back, Frederick, had some questions for both speakers. So Frederick, please let us know, what are your questions?
Hi, everybody. Thanks for the two super interesting presentations. First to Quan Li, I'm curious what Shashu means in the sentence, Shashu through big data. Does it mean discrimination or something like that? And I'm also curious whether you told that mainstream media in China and I think a consumer organization both reacted like negatively towards personalized pricing and dynamic pricing. I was wondering whether you see differences in the reaction of the public in China and Europe, or whether that consumers have basically the same idea. And I also have a question to Fabrizio, but perhaps I do that later, or?
Yeah, perhaps Tian, you can take the floor now, and then Frederick, we come back to you with the next question.
Yeah, thank you for your question, Professor. As for your first question about Shashu, Shashu through big data, actually it has a similar meaning with AI-enabled price discrimination. It means that the undertakings offer different prices to different customers based on the portrayed experience, shopping experience. Maybe, for example, their capacity, financial capacity, their preferential, their preference. So to conclude, it has the similar meaning with AI-enabled price discrimination. And for the second question, yes, indeed, I find the materials about the negative judgment from the consumers, but I also point that the AI-enabled price discrimination might do good to the efficiency, as I showed in my slides. It may, it can provide provided consumers customize the products and service that may lead to the positive gains to both businesses and customers. Yes, I hope this answers your question. Thank you.
Thank you very much. And I'll first let other people speak, perhaps, or can I ask a brief question to Fabrizio too?
Go right ahead.
Sure. Fabrizio, thanks. Could you explain a bit what the reference price would be? Because I can imagine that a company that engages in dynamic pricing, where the price fluctuates all the time, or a company that offers many people a personalized price, that it becomes very debatable what the reference price is.
Yeah, so you are right, but I also think that if we focus on the legal bases that are likely to be used, and here I am generous because I think that it is probably possible, if you commit only to apply discounts, only also to use legitimate interest. But the point is that if you do not commit to do that, then you will have to use consent. And then either if you try to bound, you have the constraint that consent has to be freely given, right? So bundle consent to something like this, I think is not going to fly.
No, I agree.
So this means that you can deny consent and they need to offer you a price nevertheless. That is the impersonal price.
Yeah.
It is a price that is calculated without taking into consideration any personal data. If the market is a dynamic pricing market based on fluctuations that are related with supply, then the reference price is going to be dynamic.
Yeah.
Fine, no problem. But the defense that no, I'm sorry, I'm not offering impersonal prices, I think that under the GDPR it cannot fly.
Thanks.
Very interesting points. I see that Antonio has a question, but Niels also has a question that relates to what Frederick just asked. So Niels, perhaps you can address your question first, and then we will go to Antonio for his own question.
Yes, thank you, Catalina. Can you hear me?
Yes, and we can also see you. Hello.
Good, hello. Regards from the faculty in Maastricht, where I'm illegally staying for the moment. Now, I already indicated in the chat that I would like to briefly follow up on the question that Frederick asked to Chen, but basically my question also goes back to Frederick, because I remembered that yesterday he mentioned that he did some research about how consumers feel about the fact that there's price discrimination, where you basically said that they were very negative about it, right? And then I was thinking about making a remark, but the discussion was very full. I think that the problem here is also that consumers don't realize that often price discrimination can be to their benefit. So it's just simply a matter of information asymmetry. So you have to be very clear about what you ask them. Do you like price discrimination? No, because it's easy to see that others profit and you never do. Whereas in fact, as Chen was explaining, second and third degree price discrimination, like student discounts, elderly discounts, you name it. It's all price discrimination. It's beneficial not only to the firms because they can sell more, but also to the clients because they can now buy at a lower price. And everyone will at one point be old or a student. Maybe not everyone will be a student, but old, hopefully, yes. So when we need it, we will also benefit from the price discrimination. So I think it's just an extension of the answer that Chen gave to you. It's difficult to find out, I guess, what consumers really think in China or in Europe. So I'm actually quite interested in your research, Frederick, but maybe you can mail me something about it at some point. So that's it for now. Thanks for the interesting presentations, both of you.
So Frederick was very kind to already place his research in the chat. So Niels, you can also retrieve it from there. Frederick, anything else to mention about these points?
No, thanks, Niels. Nice to meet you. Thanks for your question. We agree that we were actually somewhat surprised about the extremely negative reaction of the general audience, and we did our best to ask the questions. We didn't use the scary word discrimination, for instance. We, in really dry, neutral terms, described situations where prices differed. So you could indeed argue that the general audience is wrong in some of their opinions. However, that's a difficult claim to make, right? If you ask people, what do you think about something? And they say, we hate it. It is somewhat difficult for us academics to say, actually, you're wrong. But then again, in a democratic society, we do that often, because if a racist party wins the elections, we will still say, well, you can't implement racist measures because we have a constitution. So we are used to doing it sometimes, that democratic opinions don't count for everything. Nevertheless, I think we should take it into account. But I'm not at all saying that you suggested that we should ignore people's opinions.
No, but sometimes you win, sometimes you lose. So it's difficult to talk about price discrimination as one thing, you know?
It's an empirical question. I'm not sure whether the same people will always win. I suspect that non-educated people who are less who find it more difficult to keep their browser free from cookies, etc. I suspect that, as always in society, the well-educated win and the lower-educated lose, which correlates with being poor. On average, I suspect, sadly.
I also saw some very strong opinions that Fabrizio was expressing. So you will also agree that there will maybe the losses are not going to be spread out so evenly. So Fabrizio, what do you think about that?
Oh no, absolutely. So what essentially I think the economic research on this also shows that what you're going to see is an increase in market segmentation. So where originally you had one uniform market, then potentially now you have three, because you have a market, a pool of consumers that is where you have stronger competition among firms, and then you have pockets of consumers where you have less competition, right? The example of the new customers switching costs, or so brand loyalty can be used against consumers, right? Switching costs can be used against the consumers that do not switch. What we see is that the herd protection that you have when the market works, market mechanism work uniformly, you lose that. And that is why, for example, I think that in interpreting the provisions of EU law that apply to this, we really need to think carefully about how to factor in these elements, that the herd protection that comes from a uniform offer is lost.
Thank you so much. Tian, anything to add to this, and also the remarks that Niels was mentioning in particular?
Thanks, Niels, for adding for the clarification.
Alrighty. Well, thank you, Niels and Frederick, for your very insightful questions. Now we're going to move to the next question, and I would like to invite Antonio to address the question. Very nice to meet you online, Antonio, as well.
Nice to meet you too, Catalina. So I actually have a question with Fabrizio, although I have to admit I'm biased because we already discussed the very basis of his work. So I was accustomed with that. I was aware of the topic, but there is a doubt I still have, and I want to see actually if he moved a little bit forward in that, which actually is related to the potential problems related from the right to know the impersonal price in terms of manipulation and therefore consumer protection. Because what I see is a risk if consumers need to be shown a non-personal price, that firms and companies might actually force and push higher non-personalized prices in order to downgrade them later with personalized prices and actually have consumers perceive that they are receiving a discount. So we might have actually an inflation on non-personalized prices. Now, we might intuitively solve that and respond that to saying that we might have competition on non-personalized prices. So of course we might have firms competing on that, and then eventually in a competitive market have non-personalized prices be lower. But I think that this could be verified only in two chances that might not be that likely to happen. And the first one is if many consumers actually opt for non-personalized prices, because that means that there is an incentive actually for companies to compete on non-personal prices. And of course, this should be empirically verified, maybe. And secondly, assuming that consumers do care about the comparative pricing, so the non-personal prices, even when they require a personal one, and therefore they don't look only at the final price, the personalized they got, but also to the first one, the non-personal one. I don't know if Fabrizio has some, I don't know, further clarifications to make about that.
So thank you, Antonio. So my intuition in this regard is that we need probably an information requirement that is similar to the one that was added to the price indication directive, that is related to discount announcements. So that is meant to ensure that the discount is genuine by introducing a legal mechanism for calculating the reference price. We cannot apply that provision analogically. We can only be inspired a little bit by the mechanism, and we need to then think about what would be the mechanism for calculating a genuine list price. So for example, if you apply a discount of 10% to all your customers, so this is the simple case would be if you apply a 10% discount to everyone, then your reference price should be 10% lower than what you're actually declaring, and you're not applying a discount to anyone, right? So I think this is the direction that we should consider, because the chance that this manipulation happens is quite significant, I think.
Thank you so much.
Antonio, anything else to build on that?
No, that's pretty clear to me. Thank you.
Thank you so much. I see that also Caroline and Pedro had some questions. Caroline, would you like to express your question in the remaining time of the discussion?
Yeah. Okay, thanks, Catalina. I also have a question for Fabrizio. I agree with you that effective consumer protection requires that consumers know the non-personalized price. But I wonder whether in that case, personalized pricing would still be beneficial for undertakings. Would it not just result in have the same effect as prohibiting personalized pricing? Do you expect people to still buy the goods if they know that they are paying more than the non-personalized price?
Thank you. I think that if we are dealing with normal consumption goods, the answer is probably no. So I hope that this making the surcharge transparent is going to avoid that for headphones and stuff like that, you can have a surcharge. But I also think that it is not impossible to firms, especially when they have some I don't know, sustainability or fair trade element in their offer, to be able to convince consumers to pay a little bit more, because that contributes to a common good goal. And if certain consumers have a higher willingness or ability to pay, then probably you can bring them in. So I think that this is a good policy reason for not prohibiting surcharges, but then putting a very significant burden of persuasion on the trader. And then the other reason why I think we cannot expect to simply ban them is that we just had an information requirement introduced by EU law now in a provision of maximum harmonization. So I think that for the next 5-6 years, if we're lucky, at least there will be no window of opportunity for introducing additional rules on this kind of practice.
Okay, thank you.
Thank you so much, Fabrizio, for this answer. And once more, thank you both for your presentations. Now we're going to move to the second part of the panel, and we're moving from legal and behavioral scholarship on price discrimination to some hardcore natural language processing. So I would like to invite the next speaker, Andrea Grigoriou, who is going to present joint research she has been doing with Thales Bertaglia. And Andrea is a PhD candidate who works right now at the Institute of Data Science, but also at the Maastricht Line Tech Lab. So she's one of our 14 computer scientists, and she's going to speak about her research on hate speech. Andrea, take it away.
Hi, everybody. I'm gonna just share my screen in a second. Okay. Is it okay? Can you see my screen?
Yeah, it's perfect.
Yeah, so this is one of the projects that's part of my PhD research, abusive language on social media data through the legal looking glass. And as Catalina mentioned, I'm working on this with another PhD candidate. First, I wanted to tell you a little bit about the general motivation of why we're doing this project that maybe has nothing to do specifically with hate speech research, but just in general, our motivation of why we wanted to build a framework. So a high quality data set is usually the first building block for future good quality analysis and developing all kinds of algorithms like classification algorithms, for example, that can be used in content moderation. However, we have various variables that are involved when creating a data set. Usually when people think about, oh, let's create a data set, they mostly think about what specific data they want to collect, if it's text, if it's images. However, we have many more things involved, like the data collection process, the definitions that we are using to label our data, so to define our data, the labels that we are using after these definitions, which usually people don't pay that much attention to. They just go to binary label of, yes, this is something, no, this is not this. And also the annotating team. So therefore, creating an appropriate framework with all these variables included can be an important step in building a high quality data set. Our specific research question for this project was mainly how can legal provisions be transposed into a computational framework for identifying abusive language in social media text. For this, we developed a framework which contains legally inspired definitions to label the data for abusive language. And this framework has several blocks to it, and I'm going to go through each of them in detail. First, we have the data collection method that we used, then the definitions, which are legally inspired, and I'm going to give more details about it later. Then we also really tried to model the labels that we used. Usually people in hate speech research, they focus on, is this hate speech? Is this not hate speech? Is it harassment? Is it not harassment? Most people don't really think about what the level of harassment is, or if something is unsure. However, this is a very sensitive topic, so people can also be really unsure if something is hate speech or not. Also about our annotating team and the training that we also did with our annotators. So first, to start off with the data sources and collection. So we chose to collect data representing the real world scenario, as we called it. This basically means that instead of trying to bias our data to get more hate speech by using keywords that are associated with hate speech, we basically collected all the data that was available from the videos that we collected. We chose YouTube as a social media platform to collect our data, since it was underrepresented in the state-of-the-art research, but it's actually the second most popular platform. We are also focusing on videos with controversial discussion topics. So instead of just collecting data from the whole YouTube randomly just using keywords, we actually focused on specific topics. which are veganism, gender identity, and workplace diversity. We also try to focus on specific types of videos. The first ones would be official videos, which are basically posted by sources such as documentary channels, news channels, and so on. Then we have the personal videos, which are the most common videos on YouTube, the ones that we all know about, posted by influencers, and also reaction videos, which are videos posted in reaction to these personal videos, but could also be posted in reaction to official videos. We collected mainly text data, so we don't have the videos or images or anything else. And for this project specifically, we focused on the top comments from the videos, so we don't actually have the replies to the comments. The next the block of our framework are the definitions. So for this, we chose to provide definitions with legal grounds instead of just creating general definitions for what abusive language is. So in the state-of-the-art research, they usually try to define either online harassment or hate speech by using maybe a dictionary definition of this, or by letting people just decide if they consider something abusive without even giving them a definition. However, we thought that by creating these definitions with legal inspiration, we have a better ground to stand on if this research would have to be, for example, reused by other people. So for definitions, we focused on provisions connected to abusive language that have topics like incitement to hatred, insults, belittlement, threats, and so on. And our goal was not to actually transform these provisions into a specific framework, but to somehow try and get the common parts of these provisions and harmonize them to create some rules that our annotators could use to label the data. For this, we analyzed provisions from 4 jurisdictions: the Netherlands, France, Germany, and UK. After the analysis, we actually came up with 3 main questions, which to our opinion kind of describe 3 general trends that the provisions show. So the first one would be this incitement to hatred spectrum. Does it incite hatred, violence, discrimination against a particular minority? Then we have this spectrum of threats, violent behavior, and offensive language. And lastly, we also have degradement, belittlement of a person and a public opinion. The next thing are the labels. So as I've mentioned, usually people in hate speech research try to just use binary labels when they create data sets. However, we tried to see if maybe using something more specific, like a scale, could actually help improve to understand the data. So for this, we have a 7 Likert scale that goes from 1 to 3 for the non-hateful spectrum, with 1 being certainly this is a non-hateful example, and 2 and 3 could be maybe some jokes with some irony in them, and so on. Then number 4 represents uncertainty. So if the annotator, the labeler, is really uncertain if the example falls into the hateful spectrum or not, they have the possibility to actually label this. And then we also have the hateful spectrum from 5 to 7, with 7 being certainly hateful. For the training and the annotators, we actually tried to build up a team of annotators from the law faculty. So we used students. We had a total of 6 students, and also we tried again to use, well, not specifically experts in hate speech, but people with at least some legal expertise compared to maybe using crowdsourcing workers that maybe cannot be actually trained in this specific topic, or maybe they have no legal background or no knowledge about hate speech research or anything. In addition to this, so even if they did have some expertise in the legal field, we actually decided to train the annotators. This is also kind of uncommon in the state of the art, because people just think that by providing maybe a manual with instructions or just a simple list of instructions to the labelers, that would be enough. for them to understand how to label the data. However, we thought that by doing some training with them first would make them more familiar with the data, with the instructions that they have to use, and also we could actually adapt our instructions to be more understood by the students if necessary, or to just solve misunderstandings. We ended up doing 3 training rounds, after which we actually continued with the real labeling task. So I wanted to show you a little bit about what we actually did in the training. So for the first meeting, we started by using our labeling platform. We used Ocano, and we just, all of us, we were in a Skype call because this already happened when we had to work online. And we went through some comments together, we discussed them and labeled them together. And then we gave the students an assignment of 200 comments that we afterwards checked to see how well they performed. For this, we already have some disagreements. And after talking to the students, we realized that even though we did give them a manual with instructions, they were taken into account, so they knew where to find them and they were clear and so on. But since this is such a sensitive topic and it can become subjective, they were trying to focus more on their ideas about what hate speech is, instead of just focusing on the instructions that they were given. So for the second meeting, we wanted to somehow try and fix this, and we actually made a sample of difficult comments, so comments that were really mislabeled in the first meeting, to try and discuss those with the students, and again, give them an assignment to do by themselves. What we didn't do in the first meeting, and we wanted to make sure that we do in the second meeting, was to somehow try to see if they actually use the instructions. So we actually told them to mention which of the 3 questions they're using when they are deciding that something is hate speech. So this could be 1 or 2 or even all 3 questions. So this also gave us a little bit of peace of mind that, okay, they are taking into account the questions and they're not just using their own judgment for this. For the third meeting, we actually did something different. So for the first 2 meetings, this happened on the platform, the Ocano, and basically students couldn't really see what other people are labeling. So it was just a discussion through the Skype call. However, for the third meeting, we thought it might be beneficial that people would label comments at the same time. So we used an Excel sheet where everybody could see what the other people are actually labeling for each example. And then they could also see that, okay, if for this comment, we have a majority of people assigning non-hateful comments, we have 1 person that is assigning a hateful label. And then we could have a discussion of maybe what went wrong or what happened there, that it's just 1 person that is so different from the rest. So for the results, these are some results for the training sessions for what we call the normalized scale. So for non-hateful, uncertain, and hateful, you can see that there's definitely some improvements in the agreement. Of course, the improvement is not huge because hate speech is very, very hard to detect. And as it was already mentioned yesterday, it's very hard to reach high-level agreements in these tasks, even if we do have proper instructions and manuals and training rounds and so on. So this is an example of what we actually gave the students in the labeling manual. So they had some diagrams such as this one, where they would start from a YouTube comment, then they would have all the questions, and it was clear that they shouldn't use all of them at once, so they could choose at least 1 of them, and then they could go and assign a label considering if the comment is hateful or not. So going back to the initial thought that I presented with this framework that we developed. So basically for the data collection, we try to focus on data representing the real world and not try to bias our data by trying to only extract comments that have hateful keywords in them. Then for the definitions, we actually tried to create our own definitions inspired by legal provisions. For the labels, we try to not use binary labels and see if this helps the labeling process, if it makes it easier, harder, and if it can offer a better understanding of the comments. Then for the annotators, we went with people with some experience in the legal field so that they could understand the concepts that we are showing them a lot better, and maybe we wouldn't have to put in so much work to even explain the concepts to the team. However, even if we did have all of these, we still organized some training sessions with them to solve the eventual disagreements that we could solve. So therefore, I also had a thought of, could we actually reuse this framework for other applications? And my opinion is yes. So if we take a step back and we just look at the general overview of this framework, it has nothing to do specifically with just hate speech research or just social media annotation and so on. I think it can be applied for different projects that require annotation from specific fields like social sciences or the legal domain, and they mainly have the same ideas. So we should always pay more attention to the data collection process and representation issues that we might have. Then for definitions, instead of just taking what the research has previously done, maybe we could try to see if we can collaborate with the people that have some knowledge already in the topic that we want to annotate data with. So maybe computer science and legal scholars can collaborate in this example. Then we should really pay attention to the labels, even if it seems like such an insignificant step in the annotation process, to not just jump in and use binary labels because we think that might be the best option. We should try to model the labels for the specific task that we are trying to solve. Then for the annotators, we should really think about if we actually want to use crowdsourcing workers, so people with no experience, people that we maybe cannot specifically contact and ask if they have any questions, or we cannot actually train them and organize sessions, versus actually having a team of people working on this with some experience. Then also we also think that having at least 1 or 2 training sessions is very, very important to see how people understand the project, how they understand the task, and if we can already solve some issues that might show up later in the process and in these training sessions. So basically to familiarize the team with the tasks and the rules. So this was everything. Thank you.
Thank you very much, Andrea. This was really wonderful to see. So for those of you who might have been here also yesterday, if you remember, Wana Goga actually presented a study that was based on the annotation, or that aimed to annotate political ads. And for instance, in that framework, there was 1 annotator. So keep that in mind when thinking about ways in which annotation processes can lead to perhaps more substantial and more accurate representations, for instance, of either societal or legal knowledge. So that's very interesting, Andrea. Thank you so much for sharing with us the work that you're doing with Thales. Now we're going to move to another presentation that deals with NLP, more specifically applied to the idea of discrimination or bias that we might see in hiring practices. And this research is going to be presented by Richard de Frissen, who is a student at Maastricht University, and also by Rohan Nanda, who has been his supervisor in this project. Richard, I believe, is the one who will be presenting today. Richard, the floor is yours.
Yes, indeed. Thank you. So, yeah, as mentioned before, the subject of my thesis is identifying bias indicators in the recruitment process by the use of NLP, natural language processing. Okay, first some notes about myself. Yeah, I'm 24 years old. I did a bachelor in IT with a specialization of business intelligence on the Zuid University in Heerlen. Now I'm a master student at the Business Intelligence and Smart Service of the SBE faculty at Maastricht University, and I work part-time as a trainee business information management at Thomas Rahu International. Okay, so we're first going to talk about the problem itself, why we are writing this thesis, the approach, previous research, and the conclusion. So the problem itself, when we talk about discrimination and bias, everyone knows what we are exactly talking about, and that's positive on the one hand and negative on the other hand, because when we exactly know what we're talking about, it means that it is happening right now, but that's also positive because when we know it's happening, we can deal with it and we can maybe strive it out of the world. So that brings us to the following problem statement of the thesis. Resume screening may reveal certain information which consciously and unconsciously influences the HR person's decision about the candidate that gets called for an interview. For now, we are scoping on both resumes and job descriptions. In the future, we want to bring that back to maybe resumes only. But because we don't want to exclude too much in an early phase of the thesis right now, we are including both. Let's see. When we are going to look into articles written by previous authors, we see different types of bias. Of course, different types of bias can occur in resumes and can be present. So, for example, we see a very familiar one, I think, which is gender bias. Obesity bias might be a little bit unfamiliar for most of us, but imagine that someone put in a picture of himself or herself, and that person is suffering under overweight, then that person might be discriminated or biased already before even showing his potential value to that company. Age bias, racial bias are familiar as well, I think. We all face that issue that if you get older in a certain field of work, you're not being the selected one in the recruitment process, and I think that's very wrong. Racial bias, of course, is also very wrong. I think every kind of bias and discrimination is wrong in the basis. And then we are looking at ethnic bias as well, which is somehow in the direction of racial bias, of course. And then different treatment and discrimination and differential effect discrimination focuses on the way people are being assessed by a recruiter, while not focusing on the real competences of a person may have. So if you are looking at some resumes, for example, and you see someone's hobbies or someone's martial states, you may be biased by these variables. When we look at previous research, we see some very interesting part of articles, I think. Binary in 2018 focused on the extent of discrimination against skilled immigrants from Asian backgrounds. In that study, they focus on Canada only. And what they saw that people with non-Anglo names were discriminated by resume screening. And they focused on particularly the differences between the large and modern companies and organizations, and the difference between those and the smaller organizations with fewer human resource management capabilities. And the second one, evaluating bias in Dutch word embeddings, they show that recent research in natural language processing has revealed that word embeddings can encode social biases present in the training data, which can affect minorities in real-world applications. And the results suggest that, among others, gender bias is present in traditional and contextualized Dutch word embeddings. And they highlight how techniques used to measure and reduce bias created for English can be used also in a Dutch language set of training data. The third one, assessing demographic bias and named entity recognition. Their analysis shows that models are better at identifying white names across all data sets they tested, with higher confidence compared with other demographics such as black names, for example. If we are going to look at several examples of results of other papers, we see here that Bullock-Bazzi et al. In 2016 focused on the word-to-vec software that is trained based on a corpus of Google News text. And they show that gender biases exhibited strongly in the set of occupation words and amongst analogies. And what we see here is that the differentiations between the words for the she and he gender contain significantly bias and fall within common stereotypes of gendered occupation. Let's see. Okay, so the second example, which propose a model to reduce bias in the recruitment process. For example, this article states that over 98% of North American companies use resume screening as the first selection hurdle. And this model states that when non-job related stigmatizing applicant information is presented in resumes, personalized information is rather limited. And that can increase the risk of biased applicant impressions and discriminatory decision making. And when we go to the last example of results, we can see that a whitened resume, which this author actually presents in his article, has significant advantages for certain people like Black applicants or Asian applicants. And we see that whitening a resume was actually blinding a resume, called in my research, my thesis, has a significant positive effect for these two groups of people. And yeah, you see how more is being whitened, how better the results are for them to get a call back from their recruiter. Okay, so the research questions in my thesis are in general covered by the main research question: how can we identify possible bias indicators by the use of NLP present during the process of resume screening? I did split these up into 4 sub-questions. At first, I want to know how is a resume even being assessed and viewed, which elements are considered important by recruiters and maybe automated processes and others involved. And by the second question, I want to know, okay, do recruiters even weight certain pieces of information in a resume? And is resume screening without even knowing someone's race or someone's age or anything else biased by itself already? And the third one, is the input for the last one. And by the third one, I want to classify or identify, I need to say, possible bias indicators on the resume. And by answering the fourth question, I want to see, okay, how can NLP help us identify and blind these indicators on the resume. And what we want to achieve in this master thesis is develop a Python application by the use of the Spacey package. And on the right and we can see an example of a resume. All highlighted elements are possible bias indicators. At least I can imagine that they are possible bias indicators. Work experience dates can indicate someone's age. The university someone studied on can indicate someone's race or country. And on the top, you can see nationality, date of birth, marital state, and email. Yeah, of course, they are all indicators that can identify someone's ethnical background or race, or yeah, for example, that obesity bias, which I mentioned earlier, can be identified by the picture on the right top. And I'm not specifically focusing on that picture. I think I will exclude it from my data set, but just to give you guys an indication of what possible bias indicators may be present on a resume. Yeah, of course, we need data sources for the training set of resumes. We will be using web scraping, which is up for about 90% sure, because it's really hard to find a qualitative data set of resumes. Yeah, I'm currently in the Gdpr privacy process of the university, and due to the highly sensitive data which I will gather by the internet, yeah, we need to take some good security measures. Yeah, as a conclusion, we have 3 points. So we have the systematic literature review, which I'm performing right now, to gather information and knowledge which can be used as an input for the NLP application in Python using the Spacey package. And of course, we need data sources. And these 3 components are going to form a unity together and deliver, hopefully, a tool that can identify bias indicators and apply them over a resume. And that was my presentation.
Thank you very much, Richard. So I would like to invite now our audience to ask questions. And since I see that, Richard, you're at the beginning of your thesis process, perhaps what we can also do is focus a little bit on the actual data collection. So this overlaps very much with what Andrea has been talking about, how to optimize this data collection and how to really create an ethical and a very solid legal framework that permits this type of collection. So I wonder if there are any kind of questions in the audience. I saw that there were some discussions about the earlier panel. I have some questions myself, but I will maybe ask them later. I see Pedro has a question. Pedro?
Yes, thank you very much. Yeah, in fact, I mean, this is super relevant and it connects very well of around the topics we were discussing yesterday related to framework for annotation, right? And yeah, I mean, Andrea, you mentioned a little bit of the threshold between what do you want in your framework. So you want like high quality annotations, then you need to train more, but then you can annotate less, right? Or you want to annotate a lot because we want to actually annotate prices of products that might be discriminated, or we want to annotate ads. Then if you want to annotate ads, you need to annotate, I don't know, 10,000. And then, you know, yeah, you don't have the time or resources to actually train, you know. So that's part of the threshold. And so because in each one of these frameworks, you need to make this choice. Do you think would be kind of an idea, or are you considering, Andrea, on your work to actually incentivize other researchers to actually take a look at this? Like, you know, there's a threshold on the decision of your annotation framework beforehand, right? Are you planning to include these, making some advice to others, or because people would just say, okay, let's annotate, but there's a threshold to decide, right?
Yeah, you're very right, Pedro. We are actually planning to kind of redo the whole process, but maybe using crowdsourcing or just people with no legal expertise to see how well that works, because that of course can scale up. But yeah, for our project, like you said, it's basically a give and take. If we want to do something more of high quality, then we have less examples. But yeah, it's in a plan, but not done yet.
Any other questions, Pedro?
Yeah, and then I would refer then to research, because you mentioned that you would collect then these characteristics of or labels using scraping, right? So then when you capture them and when you collect them, you in a way need to again label, right? So it's like this part of the resume indicates this. This part of the resume would indicate that. And perhaps, you know, because there's no gold standard or meta information, you might actually put, you know, make your hands dirty and actually do some labeling yourself. Have you thought of that?
Yeah, I did a little bit already, although I'm not fully in the development phase already. So to give you an indication, I think it's really important to know that when you look at websites like jobpostingsfree.com, where people can upload their own CV, their own resume, I mean, you see that people really differentiate in the structure of their resume. So some people begin with their age, other people begin with other information, of course. So there are no predefined fields of data. So what's really important to know in the annotation process is that if you expect someone to fill up an email address besides the actual Word email, it could also includes other parts of information that doesn't really belong there. So the annotation process will include a lot of hands-on tasks, I think. But of course, I'm going to look into ways to automate it, because otherwise it will be really time-consuming. So yeah, there's definitely something to take a look at. But for now, that's all I can say about it. Yeah.
Yeah, good. I would just react to that. Like, I guess the suggestion of Andrea of getting some inspiration from actual legal frameworks, so you don't really come up with things. I think that would be an idea. I'm looking at Rohan. Maybe, you know, there is something out there related to bias and discrimination on hiring processes in the legal sphere, more or less.
Yeah, definitely worth looking into. And right now we are just had a look at the literature from the bias point of view and what are the different kinds of bias, ethnic, racial, and try to categorize them and then develop certain kind of annotation guidelines where we basically say, okay, email or phone number or this kind of information is a certain type of bias, and maybe name is a certain kind of bias. Or some indicators can even indicate multiple bias, you know, if like a male or female, so you also have gender bias there. So I think this kind of depends also on the domain. So like this here is focused more on recruiting. So I'm curious to see in the legal domain what kind of guidelines or definitions have been used, which we can somehow reuse for our annotation.
Thank you so much, Pedro. Does that answer your questions?
Excellent.
Wonderful. I think so. There are some questions also and some comments I see in the chat, but perhaps we can also discuss how these two annotation or these two data collection frameworks that have been presented can learn from one another. So, Andrea, do you have any idea about how to relate to the employment discrimination, selection of biases, or any comments on that?
I was planning to ask Richard a question. So you mentioned that you're gonna use web scraping to get resumes, but are you planning to somehow make sure that you have like an even distribution of, I don't know, female resumes and so on, or are you just gonna just take whatever you can find? Because also I think maybe the data source will be important. It depends on where you're going to get your resumes from and so on, because that's very well connected to what I was talking about as well. If we just focus on getting specific resumes from specific people, then when we annotate them, we might miss out on some stuff.
Yeah, exactly. Yeah, what I thought about earlier was if you're going to look for a certain job, maybe in the IT we see less females than males, for example. So that's definitely something I don't want to do. Is I want to focus on a large public in that case. So I'm not going to focus on a particular job or a particular domain. So I want to include an architect, for example, include a doctor, include a nurse, etc., etc. So I think that way you also get a good diverse data set. Of course, it's worth to think about whether having an equal amount of females and males to include in your data set. But then again, I think there's also some bias in certain job fields. So yeah, I didn't really thought about it that much. But one thing I know is that I'm not going to focus on one particular job domain, because that can cause bias by itself. Of course. But it's definitely a good point to think about. I'm going to write it down. Thank you.
Thank you, Andrea. Any other comments?
No, that was it.
Wonderful. So maybe what I would like to add before giving the floor to Caroline as well, what I would like to add would be that it would be really nice to see in your paper maybe also a section on the legal limitations and also the sensitivity of this type of data. So I see that Sina is also commenting something in the chat about instead of doing data collection in such an indiscriminate way, kind of just doing web scraping, which I think in itself might have some legal implications that you might want to know about before starting this process. It could be interesting to collaborate with an HR company and get more structured templates or resumes as a source of data. So that would be one aspect, but perhaps it would be very important to reflect on the legal limitations of doing this type of sensitive research. I think that would be quite important. But now I would like to also give the floor to Caroline, because I think she also has some comments about how to link this to the actual topic of the conference.
Yes, well, it's not really a comment. It's more like a question. We are interested in researching discrimination in online advertising and e-commerce, and we are looking into different types of discrimination-related research, such as yours, in order to see if there are any elements there, methods there that we can use or build on to discover discrimination in online advertising and e-commerce. If you look into your research, do you see any, and if so, what are the elements you think we could transpose to researching discrimination in online advertising and e-commerce?
I could answer that first. I tried to somehow focus my presentation as much as I could on the more general points of my project. So that's why I kind of wanted to emphasize in the end as well that what we developed, the framework, if we just take a step back, can be applied just as well on online advertising, for example. So connected to the example that we had yesterday, where we have just one person labeling advertisements, if we maybe use a team of people and if we try to train them properly, and well, not properly, but at least train them in some way, and maybe build manuals that we actually put some thought into and so on, could make that better. And The same with the data collection. We should really be careful what kind of advertisements we actually collect and what they represent and what we actually want to label using the framework.
Okay, thank you. Richard?
Oh, yeah, sorry, my mic was muted. Okay, so
Or
I think
Rohan?
it's, yeah, maybe I can he can add up something on it. Yeah, in my opinion, it's really interesting. Really interesting, of course, because yeah, application processes are more and more online, hosted nowadays. Of course, with the Corona pandemic. So I think bias happening in resume screening or maybe job postings may also come forward in a different way in e-commerce and advertising. So I think there can be a relation drawn between these two, because the way of texts are being written by people can direct more to male or female, for example. Yeah, that's the most I can say about it. Maybe Rowan can add upon it.
Yeah, definitely. To follow up what Richard has said. So, I mean, when we are looking for language patterns and basically semantic analysis of these terms in job descriptions or in online advertising, you can also have in online advertising certain product being advertised in a certain way to attract certain people, right? And then maybe that's intentional on their part, but then you can say they are just biased towards a certain audience. And then in the language, you will see all those bias indicators probably, right? If a certain product is being sold to a certain group of females in a certain group of ages, so you are quite sure that you will see certain terminology where you will see these indicators. And then using systems like name entity recognition and other natural language processing models, you can capture and model them using annotation processes. So I think that there is a lot of similarity from technical point of view to address these issues.
Okay, thank you.
Wonderful, thank you very much. Any other questions in the chat? Perhaps Sina, would you like to take the floor and maybe make some more references to what you were mentioning to your comment? And Sina, let's see.
Yes, hello.
Hello.
Hi, thank you for the presentations. Well, I'm studying like labor market. I'm coming at this from a labor market perspective, and that's why I was thinking that it would be interesting to look at like data from agencies that are specializing in making matches and how they are biased. So it would be also interesting to look at maybe data from public employment services or HR companies. That's all I wanted to add. But I look forward to your research. It's very relevant.
Thank you so much. Richard, would you like to reflect on that, or Rohan?
Yeah, I can add up on that. Of course, there are already companies facilitating a bias reduction in hiring processes, like Diversely.io is a perfect example, I think. They facilitate companies in a bias-free, as they mention it, process of hiring. So they remove these indicators, which I'm about to remove with natural language processing and resumes itself. And I am about to contact them to maybe find a collaboration. Another example of a company is 8Vance or Job Digger. These companies are working together, and they also facilitate a job matching process for companies. I tried to contact them, but they weren't in for a collaboration between my research and their actually company. So it's, I think, really hard to get into a company and contact them and say, hey, hello, I want to collaborate. Please, can you give me your data set, for example, and I will give back results of which you can develop your system, because we are actually working with highly sensitive data and no one is willing to have a GDPR regulation firm on your doorstep and saying, "Hey, hello, you passed the rules." So I think that's mainly the reason why people are hesitating to do so. Yeah, but it's definitely worth to keep trying, in my opinion. So I'm, as I said, about to contact Diversleo and see whether they are in for a collaboration in any way. Yeah.
Just to add, so we are also collaborating with the Irish company, Business Point Intelligence Systems Limited, aka allsorter.com. So they have also a lot of CVs and resumes, but there is an additional overhead always to anonymize and then give the data, which companies seem to be a bit hesitant to do. But yeah, so eventually we are using open sources data set, or we will do scrape some data sets, CVs online with, of course, GDPR assessment ongoing.
All right, and I have a question myself, if I may. So, because I think I can think of ways in which perhaps the kind of methods that you would like to deploy, and also, for instance, what Andrea was speaking about, the idea of having an annotation, a new annotation method to really be very more granular when it comes to detecting hate speech, that can have applications in terms of content moderation, for instance. And then in the case of Richard and Rohan, and in the case of your research, then obviously then something that is going to be an applied version of the theoretical research which you are conducting right now would lead to, I think, if I understood correctly what Richard was saying, an actual tool that you could use to identify these bias indicators with, right? So what I would like to ask you all is, how do you make sure that then this type of or these kind of applications are not weaponized? So in the case of content moderation, perhaps one way to say, okay, there are these community guidelines for every single social media platform, but in a way, you could also say, especially when it comes to identifying hate speech related to very specific types of videos, right, Andrea? So I think you also took some political videos. You also had some controversial aspects from a socioeconomic perspective. There have been all of these discussions about how maybe some categories of voices in social media are currently being maybe shadow banned. So from the perspective of maybe expressing very conservative perspectives and becoming shadow banned. So I can imagine how, if you're able to detect something that is more granular, which doesn't necessarily entail that something is hate speech, so platforms might not label it as such, and then also might not necessarily remove it, but could still use such a granular system to identify groups which then could have their voice de-amplified from a platform. So that's an example. And I think in the case of Richard and Rohan, I think it's quite easy to think about how such a way of identifying biases could be weaponized, and then to say, well, if you're identifying a bias, why not actually apply that bias, right? And then to see how you can indeed screen out the specific protected categories, which would be perhaps in a lot of jurisdictions already a legal infringement, but which, as we have heard also yesterday, in different sectors could be still a relevant practice, again, although illegal. So I just want to ask you all, how do you make sure that you account for this type of weaponization of the systems that you're building?
So for my application, for example, it could definitely become that, because we also didn't focus just on hate speech. So we call it abusive language in the end, because we take everything else into account as well. And yeah, it can happen that platforms might remove more content than they should, and so on. But it could also have like other beneficial applications, such as, I don't know, building maybe like a filter for users where they say, okay, I don't want to see like sensitive content that might be abusive, and so on. So for me, at least, like I thought it from this perspective of like trying to help the users. But of course, it can be weaponized if a platform wants to go into a certain direction of basically silencing one group of people.
Thank you. And then maybe, yeah, something to consider, and also maybe something that we can have a separate and entirely separate event on, something to consider, and how to make sure that that maybe doesn't happen so easily. Rohan.
Yeah, so I mean, what I think, I mean, so when we started with this, so because in recruiting, I mean, you are generally the companies and everybody wants to reduce the bias. So I think this unconscious bias is already in people's minds, and even they don't think about it sometimes. So it really depends how you use these kind of tools. And of course, there is scope for weaponization and all sorts of misuse. But I think in a field like recruiting, where there is a lot of unconscious bias and people have these preconceived notions, which even they are not aware of, then probably these kind of tools are more useful. And if they are basically deployed in a way to kind of mask, like hide those kind of indicators, then you, of course, have a better chance to reduce those bias indicators. So I would think in the more positive terms rather than the negative.
Okay, good. Optimism is good all the time. Indeed. Richard?
Yeah, I think what Rowan is mentioning here is, a good one. You can better focus on the positive side right now, because bias and discrimination is already happening right now. And for example, if you sell a car to someone and allow him to drive 50, he may find a way to drive 70, for example. So people will always find a workaround to build systems their own way. And of course, there's a risk to have our application being transformed to being weaponized. As I said, bias and discrimination is already happening right now, and it could only get better, in my opinion. What you read in academic literature is that people are really willing to reduce bias in hiring recruitment processes. Yeah.
Okay, thank you so much. Are there any other questions from our lovely audience today? I do not see any hands. I do not see any comments. Perhaps then what we can do is take a longer coffee break, and we are going to resume at 3:45 with the second panel of the day, chaired by Caroline. And I would like to take this opportunity to thank all the speakers for their wonderful presentations, and also to thank our audience for staying with us also for the second day of this conference. See you at 3:45, and in the meantime, I will just put the rock music back on. Have a great coffee break.
Welcome again. I hope that you had a nice break and that you are full of energy for our last series of presentations. We will start with a presentation by Antonio Davola, who is an adjunct professor at Luis Guido Carli University in Italy, and at the same time, Marie Curie Fellow at the University of Amsterdam. He will speak about the role of consent and misrepresentation rules in regulating personalized practices. Antonio, you have the screen.
Okay, thank you, Caroline. I hope you can all hear me. And thank you so much, actually, for the invitation. I will just share immediately my PowerPoint presentation, just to make it easier, actually, for you to check that. So, so thank you so much for having me. Today, the working paper I am willing to present is actually about fostering consumer protection in the groundwater market. And as Caroline was saying, is about it aims at analyzing the role of consent and misrepresentation rules. So from rules coming from European private law in regulating personalized practices. Now, just to provide a minor contextualization before we get in depth with the project and the paper, Now, the paper is actually the first step of a wider project, which is the my Marie Curie project that is entitled Fair Personalization, and which I'm conducting with the support of both the European Commission and the Amsterdam Center for Transformative Private Law. And in the Fair Personalization project, I am willing on a, let's say, wider perspective to analyze how personalized offers of products and services have actually an influence on consumers' propensity to purchase, in order to ultimately actually try to lay down a European regulatory framework for tailored commercial practices, also considering the influence of general principles of private law, such as the principle of fairness and good faith in the digital society. Now, in the paper I'm presenting today, I am having a way more modest tune, because the paper today wants to investigate just the characteristic of rules on consent and misrepresentation as an ad interim, so as a perspective tool to incorporate findings on personalized practices, and therefore as temporary instruments for modernization of consumer protection. Now, luckily, and this is extremely helpful, since we already have extensive debate and discussion on many preliminary aspects of this topic. I will just be very fast about that. So just a minor aspects I want to precise before we get in depth with the core idea behind the paper. Now, of course, we are talking about personalized practices, so forms of personalization of the marketing experience that are related to the so-called phenomenon of customerization, which is, of course, very, very well known to marketing scholars, as well as legal scholars in recent years. What I want to pinpoint is that we have had a significant, robust debate today about price, personalization, and yesterday, especially with the intervention from Professor Miklitz on advertisements, personalization. Here I want to shift the focus a little bit by underlining that customization actually affects also the components of products, so the attributes and benefits of products that are shown on the market, as well as their presentation, choice, and delivery. So personalization and personalized commercial practices have an impact not only in terms of price of the product, but actually on a more general ground on the features of those of the products that we consider. And therefore, the paper tries actually to deal with the personalization of products. And of course, I will just refer to personalized commercial practices or commercial practices, targeted commercial practices, and so far and so on. But I'm perfectly aware that actually we are talking about an heterogeneous phenomenon that goes under different names and labels that are slightly different. So literature, of course, has discussed about behavioral online behavioral advertising, psychological targeting, micro-targeting. So there are many names to define the phenomenon. I will just try to use personalized practices or targeted commercial practices. And lastly, one other thing I want to pinpoint is that, and this is like also a political standpoint that I agree, is that in these 2 days of a discussion, we have seen both opportunities and shortcomings coming from the personalization of products and services. We have talked, especially when we have discussed about personalized prices, regarding the advantages of price discrimination, so capacity to match buyers and sellers. And of course, we can all agree, and Caroline summarized that pretty perfectly actually in her introduction yesterday, that personalized products can lower research and transaction costs and also facilitate the provision of free online content that are, as we know, not exactly free, but in which data are used mostly as a counter performance for the provision of apps and services and so far and so on. So overall, we can at least agree that some positive aspects are present in favor of a crescent degree of personalization of products and services as a factor for economic growth. And on the other side, we have all the aspects we have been discussed as well. So the problems coming with this crescent personalization that are related to manipulation of consumers and the exploitation of their bias and individual frailties. And yesterday when we talked we talked about discrimination law and the role of discrimination law in analyzing personalization. A major aspect that has been discussed was related to the so-called disparate impact and use of protected factors as a problematic aspect in the regulation of personalized practices. Now, I specifically referred to discrimination because a first conceptual point that I try to make in my paper and in my research is that we have been talking extensively about discrimination in general terms and in proper terms, of course, when we refer to anti-discrimination law. But I try to underline that in the debate of targeted practices, discrimination as increasingly becoming some sort of an umbrella notion encompassing different forms of impact, different impacts on consumers and individuals' fundamental rights. So, for example, and this goes with very easily with an analysis of the literature on the topic, legal scholars talk about discrimination when we have problems of potential exploitation of consumers' cognitive bias and heuristics, so a problem of undue influence and distinctive influence among different consumers, but we talk about discrimination extensively also with regards to the use of protected factors and sensitive information, for example, by obtaining data from consumers and using them to personalize their commercial experience. And we often, and this is actually more frequent in the American scholarship, oftentimes it is talked about discrimination from the procedural standpoint of explainability, interpretability, and respect of individuals' due process rights. What I want to actually, though, to focus on is that in analyzing discrimination, I have observed another declination that is probably a little bit less discussed within legal scholarship, and that nevertheless is pretty significant, especially in light of evaluating the role of private law rules in regulating commercial practices. And in particular, we can discuss about discrimination with regards to the capacity of targeted commercial practices to impact on the self-determination process of consumers. When consumers are offered a personalized product, she is actually subject to a modulation of the set of products offered on the market. A consumer is not shown the whole state of the market, but rather a minor subset that is hopefully crafted according to her preferences. And in addition, that specific subset is attributed a specific saliency, because that's the one actually the consumer is shown. And this has a significant effect in terms of self-determination and freedom choice of consumers, because this way consumers are not able, on the one hand, to have let's say a glimpse or an understanding of the actual state of the market, and on the other side they are deprived of the capacity, which is actually significant when we consider marketing research, to observe what their peers are doing. Because of course, if we face a significant microsegmentation, it means that consumers cannot relate to each other in order to develop their preferences. And this goes also to a wider topic that is also related to a potential idea of relational decision-making and not only an individual decision-making in consumption choices. And actually this form of discrimination is actually at the center also. I mean, it's a significant one that creates a significant bridge with private law rules. Now, of course, we have been observing, and many of them have been mentioned in these 2 days, significant attempts to regulate algorithmic discrimination. And just very, very, but very, on one hand, from a general perspective, we can try to distinguish 3 main strands that I want to discuss very briefly, to underline that they all have potentials, but they also offer some shortcomings, or at least some chances for improvements that should be considered. Now, on the one hand, of course, the functional interpretation of GDPR-related user rights has been called as a tool to regulate algorithmic discrimination. That comes mostly from data protection and privacy scholars. Now, the problem with this approach, and once again, excuse myself, this might be a little bit straightforward, but let's say time management requires me to do so. Eventually, we can get in detail in a conversation, in the subsequent conversation. So some problems with GDPR related rights used to regulate targeted commercial practices is that, of course, they are strongly related to the use of personal data and the acquisition and processing of personal data, and therefore it's difficult for these rules to regulate the systemic effect that profiling is likely to introduce in terms of self-determination. And related to the idea, actually, to the assumption that the core aspect of the problem of algorithmic discrimination lies in the characteristics of the data-driven network architecture is actually the idea of having competition law get a wider role in tackling distortion caused by personalized prices. That was also discussed in the chat earlier before. Now, I have to say I agree, I embrace that position according to which actually competition law might not be the perfect reference when we analyze personalized commercial practices for a set of reasons. One being the fact that some notions of competition law are difficult to attain to the problems created by personalized practices, such as the abuse, the dominant position or the relevant market, and are difficult to reconcile with the characteristics of the data market as well. At least this is a debated aspect. And also we might argue that the direct protection of consumers is difficult to obtain by means of the remedies that competition law usually offers. And I think that a very clear, or at least a proper overview of this problem comes from the analysis of the Bundeskartellamt decision on Facebook that was rendered in 2020. Now, I do not have time to get in depth of that decision, but I have to admit that it was extremely doubtful about the outcome of that decision, not in terms of substantive output, but by observing how competition law and competition rules needed to rely on open-ended remedies and obligations over Facebook, because actually competition law was not able to develop consistent remedies to protect consumers against the abuse, let's say, the abuse of data used by Facebook. Lastly, and not surprising, also given the discussion that we had yesterday, the vast majority, probably, of legal scholars are investigating the role of consumer law as a tool to regulate algorithmic discrimination. And in particular, much attention has been devoted to the Unfair Commercial Practices Directive, especially in light of the modifications and the changes that are happening after the Modernization Directive, and in light also of the modifications that are investing the directive on consumer rights. Now, with regard to the UCPD, so the Unfair Commercial Practices Directive, we must observe very fast that we have some problematic notion that we encounter when we used to use Unfair Commercial Practices Directive to regulate personalized practices. And once again, we have some, traditionally debated problem among consumer scholars, such as the problematic threshold of the average consumer, which is difficult actually to conjugate with the microsegmentation characterizing personalized practices. And we should also consider one other aspect, that a major problem coming from the UCPD is that is related to private enforcement, and in particular to the fact that we do not have a specific remedy that comes after the violation of the UCPD. Now, we have had significant steps ahead in this topic, and the European institutions are pushing in some way towards the adoption of a unitary framework for remedies, but still, and also towards the adoption of the avoidance of contract as a main remedy, but still the decision about which remedy to provide and under which conditions is actually still remitted to member states, and this is a major factor of fragmentation in this field. So against all these problematics, and moving from the idea that actually profiling affects contractual relations and market exchanges alike because it has an effect on consumers' capacity to generally develop their free will in contracting, comes my idea of using some notion in European private law as an ancillary resource to eventually overcome some problems some shortcomings that we are seeing in examined regulation, and in particular within contract law. I find that rules on defective consent, so rules on mistake and fraud, could provide significant tools, especially when we observe that they, from a general perspective, take into consideration all those situations and phenomena that affect the formation of a party's genuine assent and the party's free will in the conclusion of a contract, which is exactly what we are talking about when personalized commercial practices are considered. And why? And I think that there are some advantages in exploring this sort of solution. On one side, we have the fact that rules on consent do represent a common tradition amongst member states, because of course they arise from Roman law, and therefore they are common with similar structures to the vast majority of member states. And we find a further confirmation in the principle of European contract law and in the draft common frame of references, and both in member states and in proposals actually for European private law harmonization, they follow the same or at least similar structure that is the one that is depicted in Article 103 of the PICL. So related to the mistake as two factors of the law, focusing on errors and mistakes caused by the other party or that the other party should have been aware of. Now, why? Okay, this is related to the fact that there is some sort of harmonization, or at least some sort of common tradition for that. But also, I do believe that rules on consent as a framework might provide some advantages when confronted with the other normative bodies that I mentioned. And in particular, when we consider its relation with data protection rules, we observe that rules on consent share the common ground of protecting consumers' informational self-determination while exhibiting at the same time a wider and more flexible scope. And also they allow, of course, for an ex post appraisal of parties' behavior, which is highly individualized, and therefore might actually tackle properly the micro-segmentation arising from personalized commercial practices. And in addition, when the UCPD on the other side is considered, of course, we are not entangled to some problematic benchmarks such as the average consumer or the professional fairness, or even the relationship with the transactional decision making, which are significant for unfairness in commercial practices. But rather, we have a remedy that's focused on the individually segmented evaluation of the conduct of the parties, which is also important because it allows us not to make a conclusive statement regarding the tailored practice per se, but rather to observe how parties behaved in their interaction. And last but not least, of course, these rules on consent have usually a clear remedy, which is the avoidance of contract. So they provide some legal certainty in terms of consumer resources. So summarizing very fast, rules on defective consent have, while sharing a conceptual ground with existing regulatory solutions, can at least provide some sort of corrections to shortcomings or limits, or at least critical aspects that each of the other bodies of law has, and therefore can provide at least an ad interim resource to deal with the phenomenon. Of course, this does not mean, and I'm concluding, that we have a ready-made solution, because of course on one side further harmonization is needed, because then this is widely debated amongst private law, European private law legal scholars, we do not have a fully harmonized system of European private law, which is, according to my position, advisable, but goes beyond the scope of this paper. And nevertheless, I do defend that using private law as a conceptually unifying framework, it can be a practical solution to preserve consumers' free will. Also when we talk about free will in terms of perception of the market state and the characteristics of the product on the market, which is the form of discrimination I raised at the very beginning of our discussion, and therefore they can actually represent in way for more substantive and devoted regulation, a tool for protect individuals' genuine free will in the digital environment. Thank you so much for your attention.
Okay, thank you. Thank you, Antonio, for this very inspiring presentation. I'm sure that there will be many questions already, but I have to ask the participants to list them in the chat. And at the end of the session, we will have a large slot where all the questions will be dealt with in the same slot. Am I still?
We hear you again.
You can hear me?
Yes.
I'm not sure up until where you could hear me.
We missed 2 sentences maximum.
Okay, then I will just go on. We will move on to the next presentation by Professor Frederik Zuiderveen Borgesius, who will present this time together with a student of his, Marvin van Beckum, and they will discuss whether the GDPR needs a new exception in order to prevent discrimination by artificial intelligence. And well, this sounds very intriguing, so I give you the screen, and I'm curious to hear your presentation.
Yes, I think you can all see my slides right now. So first about myself. Oh, not yet. Not yet. Resume share.
Yes.
They're back. Okay. Right. So first about myself, a bit about myself. I am Marvin van Beckum. I studied law and computer science at Radboud University, and I am the new PhD student of Frederik Zuiderveen Borgesius, and I will be giving a presentation about a draft paper we are writing about using sensitive data to prevent AI discrimination. Of course, many of you will already know the information I will be giving now, but just to be complete, I will mention it. AI is in computer science literature, at least the famous books, it's called the study of intelligent agents. So it's a very abstract definition. It's often confused with machine learning in practice, which is that you have a model, and this model has input data and a set of variables, and the model learns based on the input data and the variables. And this can lead to discrimination. There are a few ways in which AI can lead to discrimination. At least 3 ways are the input data can be tainted. So a famous computer science adagium is garbage in, garbage out. So if you train an AI based on past recruitment data, for example, a recruitment system, then this can lead to discriminatory decisions in practice. It can also be that bad variables were chosen that lead to discrimination. For example, you take someone's age into account, or someone's nationality directly, and it can also happen by proxy. So checking an AI against discrimination requires using sensitive data. So if I want to know whether my AI system discriminates against a certain ethnicity, then I need to know the ethnicity of the people who are allegedly discriminated against. So an example that would happen, could happen in practice at least, is this one. In 2015, in Utrecht, there was a sample test by the Consumentenbond, and they found that there was that people from different postal codes and house numbers and even house additions paid a different insurance premium. And now you should imagine, what if these insurers wanted to test their AI and see if the AI discriminates against people with a certain ethnicity? Then they need to know the ethnicity of their clients. Of course, collecting data to prevent discrimination is nothing new. So in the last century, it was also necessary. But in this age, we live in what is called the big data age. So data is sometimes called the new oil, and this can lead to data hogging. So in this age, it is very valuable to collect a lot of data about people. The EU legislator created a regulation to regulate that, called the Gdpr, to protect people against risks of all this data hogging. And in the spirit of that, you can read the prohibition in the Gdpr to collect sensitive data, because in principle, it is forbidden to collect sensitive data, and this should be interpreted very narrowly, at least in principle. And there are a number of exceptions to that principle. So you can use, of all the exceptions, there are consent, and there are several other options that do not require consent. But those options generally require a union or state law in order to, for companies at least, to use them to collect data. And consent is a difficult ground, because you can ask yourself if it's actually freely given, because the criteria for judging consent is that it should be explicit, it should be freely given, and it could be awkward for a company to ask consent from their clients. So an insurance company suddenly asks you for consent for collecting your data to test their AI against discrimination. Well, it could be an awkward thing to do, at least. We looked into arguments for and against a union or member state law to test your AI against discrimination. And we could not find a single paper that really gives an overview of the different arguments for and against. So there are arguments to collect this data, and there are also arguments against collecting this data. And that is what our paper is about. Arguments for discrimination that we found in the literature were mostly, well, from the non-discrimination literature, of course. It's easier for companies to test their AI against discrimination. It's also easier for regulatory bodies to check if a company AI, if the AI of a company discriminates, and it's also easier for states to keep track of well, the fight against discrimination, so more statistically. These are three arguments we found, but we value any input you have on more arguments, of course. And then there are also the arguments against, and we found that there were at least two types of arguments against from the GDPR itself. Arguments that are about the mere storage of data. So it's risky to gather a lot of data in one place, and because this data can be abused. Secondly, well, collecting data can be having a lot of data, sensitive data in one place, and being part of such a big database can be awkward to people. So this is a more sensitive argument. And then there are also arguments related to the use of the data. So not just storing it, but also how it could be used in practice for new things. And it's very unclear how this data could be used in the future, of course. And well, then there are a few more arguments against. So the legislator wanted sensitive data to be well protected, and the idea that it's hawked in one place for any reason is, of course, against it. But on the other hand, you could also say that the GDPR wants to facilitate the fight against discrimination. So this is an interesting tension. And a second argument, which is probably not that convincing, but it's still an argument, is that the problem is not that big. So fighting discrimination, is it really that important to that we should collect all this data, this sensitive data? We looked for examples in Europe of discrimination, and we could find more US examples in practice, at least in the scientific literature, than European examples. Well, this was our presentation. Thank you very much, and once again, we value any input that you have.
Good. Thank you, Marvin, for this challenging presentation. Good. Then we move on to a presentation by Jingxi Liu. She's a PhD student at Queen Mary University, London, and she will talk about gender bias in online behavioral advertising. Jingxi Liu, you have the floor.
Yes, thank you. Good afternoon, everyone. I'm Jingxi Liu, a first-year PhD student from Queen Mary University of London. I'm currently working on the gender bias in AI. So I'm very grateful to have this opportunity to share my research. Today, I would like to talk about gender bias in online behavioral advertising. I have to say, I have not yet achieved any results or conclusions on this issue, but only explore the underlying causes of this issue. The first is gender bias in algorithm. The gender bias in algorithm may cause two different types of discrimination. One is direct discrimination. It means, for example, the unfavorable treatment is only due to the female factor. And the other one is the indirect discrimination. This means that a certain measure may appear to be neutral, but it doesn't consider pre-existing inequality. So I put two examples on the slide. So what I mainly want to share today is the underlying cause of this phenomenon. A piece of evidence shows more men than women can see recruitment ads for STEM positions, such as science or engineering careers. This research is to advertise on Facebook and experiment in 191 countries. For consideration of the original social factors between different countries and cultures. The conclusion of this study is that the results is due to the economic factors. So the reason the researchers first text whether men are more likely to click on this type of ads. The answer is negative. Women are more likely to click on this type of ads. More men can see these ads because advertisers are more inclined to place sales type ads to women within a limited budget. At the same time, the algorithm can automatically learn the gender of the different users. So since women are more likely to pay for ads, then when the target customers of online advertising are women, the advertisers will pay higher prices. Then that's why men will see this type of ads more often. But however, the results of this study may not explain another piece of evidence. Some people have designed a large number of virtual users to observe the online recruitment algorithm. The results show that algorithms tend to assign higher paying jobs to men. In this experiment, the user profiles and behaviors used are exactly the same, and the only different factor is gender. Then it's obvious the algorithm can automatically learn the gender from the different users and will lead to the gender bias. So based on these two types of studies, I think there is a dilemma. So should there be a new legal framework to regulate advertisers to assign equally for different genders? If ads are evenly placed on different genders, it's possible to solve the problem that women have less access to this recruitment ads than men due to economic factors. But algorithm can learn the gender bias that we already have in our real life. Then the same phenomenon that appeared in the second experiment cannot be solved. So this is the problem I would like to share today. At this moment, I'm still in the earlier stage of this research, so this sharing is more to discuss with you. Thank you very much.
Good. Thank you, Liu.
Yes.
For this very nice presentation, although you are still in the early stages of your research. I hope that our audience can help you a bit in further defining your research path. Good. Then we reached the moment of the discussion on all the presentations we heard since the break. I already saw one hand that was raised, and that was by Marta Santos Silva. Marta.
Yes, hello. Thank you very much for the very interesting presentations and for the organizers of this very important conference. I have a question. Well, actually, I have one question and one suggestion to Antonio. Thank you so much, Antonio, for your presentation. I found it extremely interesting, and in some points it overlaps with my own research interests. And I just wanted to mention a point that was, you know, in several of the slides you mentioned this this point of this manipulation critique, the fact that there might be some biases, some rules of thumb from consumers that are exploited in this process. And you seem towards the end of your presentation to favor the transparency approach. So you seem to consider that information, good information, enough information, you know, free consent, informed consent is a solution for this problem. And I was just wondering if we think about all the behavioral insights that are relevant in this domain, and if we think of consumers not as econs, like Richard Thaler calls them, but as typically irrational citizens and human beings, then is it that transparency and information is really the solution? This would be my first question. And my suggestion, or also a second question, would be, when you talked about regulation, you mentioned the GDPR, and I'm of course by no means an expert, but I was just wondering if, in addition to informational privacy, also decisional privacy should be brought in for the discussion, and perhaps even more generally, more ethical level discussion on the principle of autonomy and self-determination of consumers. Thank you so much.
Okay, should I go, or are we like gathering other questions?
No, please go ahead.
Okay, so thank you very much for both your points. And I mean, with regards to the first one, so the role of information and disclosure, let's say, as a general means of protection. No, I totally agree with you. I mean, maybe it was not super clear to the presentation due to the time that we had, but I'm totally on board with your position. I mean, perfectly aware of the old problems connected with the information overload or the no reading problem, if we want to just recall a little bit of literature. That's why actually I think that the rules on defective consent, the private rules for defective consent can provide a good solution, because they are not that focused on, let's say, pre-contractual information that has been provided to consumers or counterparties at least. But when rules on consent and defective consent are considered, courts are able to scrutinize whether the actual behavior of the parties, even after the provision of information, was meant or could actually lead to mistakes or errors in concluding the contract. So I have the feeling that they, I mean, that rules on consent and misrepresentation do provide a little bit more of a flexible scope, rather than just merely relying on disclosure and transparency. So I do not see them as necessarily related to pre-contractual information, but more in general on the parties' contempt in the in contrahendo, let's say, behavior. With regards to your suggestion regarding decisional privacy and not only, let's say, informational self-determination, yeah, that's totally something I need to get a little bit more in depth I explained that in my presentation due to both, let's say, the wider scope of the project and the time being, I didn't have the chance to get specifically in each of these problems, and totally feel like, and there I totally feel like the decisional aspect shall be further developed within the paper. So I just accept that and will definitely get you back with more insights.
Good.
Excellent. Thank you very much.
Okay, perfect. Lisa Waddington also has a question. Lisa.
Sorry, yes, I had to turn the camera on, sorry, to go well. So thank you to all three presenters, those were very interesting presentations. yesterday was also very interesting, and I was thinking about quite a few things last night. In fact, I couldn't even sleep. I was thinking about things that people had said yesterday that were that interesting. And now the presentations of Antonio and Marvin give me the opportunity to come back to my thoughts and to make some points and to ask you some questions that follow on from yesterday and which are linked to yours. So, Antonio, if I've understood you correctly, you're arguing for a kind of a more individualized analysis of the situation of the consumer in terms of what is needed in terms of protection. And of course, yesterday, Professor Miklix was talking about a reversal of the burden of proof, which would also be a more individualized approach. And I really agree with you wholeheartedly on that. But if I was playing the devil advocate, if I was thinking about how EU consumer protection law works, which I do sometimes, the goal of EU consumer protection law only, to be honest, it is protecting consumers, but only to a certain extent, because the goal is to also to achieve the internal market, so the sellers can operate throughout the market. And EU consumer protection law wants to protect those consumers, but it doesn't want to impose too many obligations on the sellers. So the approach that seems to be adopted, for example, in the Unfair Commercial Practices Directive, is to say consumers have to provide, do certain things, provide certain information, and as long as they do that throughout the EU, then in principle, their practices won't be regarded as unfair. And we don't want to have this individualized analysis. And of course, EU consumer protection law is full harmonization. It's not minimum, it's full harmonization. So the member states can't add anything extra to that really. So it seems to me that the EU consumer protection law doesn't, I mean, it actually goes against its goals to have this individualized analysis, because it's balancing the interest of consumers and sellers, and it's putting a heavy weight on sellers having clear information about what they have to do, and it's the same for everyone more or less. And it's not this individualized approach which gives much greater protection. So I very much like your ideas and those of Professor Miklix. I just wonder, how does this relate to what I think are the underlying goals of EU consumer protection law, which is protect a bit, but not so much that we need to have this individualized analysis. And then if I may move to the data, data protection and Marvin's presentation with Frederick. So yesterday we were talking about positive action and how it may be possible to use AI to identify certain groups and then direct that positive action at them so that they charge less or they have access to programs or something. And I was thinking yesterday, well, how do we assess whether collecting information through AI for positive action is permissible or not? And do we say, well, if the positive action is permissible, then by definition, the collection of that data, for example, on, let's say, health status and protected ground, the protection of that data is permissible because the positive action as such is permissible. So if it was out there in the real world and they weren't collecting data in this way, it would be permissible. Or could it be that the positive action is permissible, but it's not permissible to use AI to collect data? And the conclusion, the tentative conclusion that I came to was that the general data protection regulation would, in some cases, prevent the collection of information about personal characteristics through AI, even if the positive action measure would be allowed. So I wonder how that kind of feeds into your thoughts. Is that relevant in any way? Does that mean that we should be is that an extra reason for saying that there should be special rules for AI, or does it confirm that the rules that the data protection regulation provides are the right rules? So that was what was keeping me awake last night, both of those two questions. Thank you.
I'm so sorry. I hope I didn't help. I wasn't one of the people responsible for robbing you of sleep. I'm sorry.
It's all my own fault. No one else's fault.
Yes. Good. Who wants to start answering this question?
Same for me. If you want, I can just go, Marvin, and then give the floor to you. So thank you so much for the question. Actually, I mean, I do not see like your point being totally incompatible with what I was trying to argue for. Actually, and this was a thought that I had. I mean, that was a common thought that I had with you when I listened the Professor Mikli's presentation yesterday, and I didn't have the chance to raise that, but I do believe that the reversal of the burden of proof is not like the perfect or the most suitable solution for a set of reasons. One being the aspect that you were mentioning. So the fact that actually the protection of consumers and individual consumers is only one part of a wider framework that consumer protection in the European Union was trying to achieve. And this was true, especially in its early days, I would say. I mean, nowadays we are seeing, I would say, a convergence of consumer protection, and I think this goes also for competition law, a convergence towards more substantive justice orientated evaluations. That's something that we see, for example, from the Facebook case that we mentioned, but we can still, I would say, hold to your point, which is correct. And another problem that I saw with the UCPD is that we still have some thresholds that are actually against this idea of an individualized judgment, because we can argue in favor of an individualized judgment, but then we still have the average consumer benchmark and other forms of, let's say, standardized evaluation. That's actually why in the paper I try to defend that private law rules might offer a perspective counter-argument or a perspective solution, because whereas, as you correctly point out, consumer protection and the UCPD are bound to this form of consideration of collective or consideration to the consumers, private law rules do embrace more of individualized scrutiny. That's why I thought that was the idea behind the paper, that actually we might try to shift a little bit the focus from consumer law to private law and evaluate private law rules on fraud and misrepresentation, rather than the misleading commercial practices regulation or the aggressive commercial practices regulation. I hope this provides like a perspective solution. But
anyone who wants to add to this answer?
No. Marvin, would you perhaps want to answer Lisa?
Yes, I would like to answer her question. So if I understood your question right, it was that under certain circumstances the positive action can be permissible, but the GDPR would not allow it. What I think personally, because our paper is simply arguments for and against, so it's a little bit more objective, but we think that if you do allow it, if you do make an exception, then there should be specific laws that specify under which conditions you can actually collect this data and use it to stop discrimination. An example of a law is the UK data protection law. So this one is an implementation of how this could be done, and we could perhaps learn from such practical examples. I think that finding the right balance here is difficult, but I do think it can be done. But it might be something that has to be done in practice. So we would have to learn from practice, I think. But, well, I think it's an interesting perspective. Frederick, do you have something to add?
No, I agree with everything what you say and with the points made by Lisa, but I wanted to add that so far, Martin and I found quite a pile of literature which completely predates the big data discussions. And then you have non-discrimination scholars and policymakers, and they say data protection law is drafted wrongly, or they say people misinterpret it because it's clearly possible to collect these data and it is so important. And I agree with the so important argument, but I don't agree that that you can interpret data protection law easily to enable it. And you have data protection law scholars who tend to say, well, it is without additional laws, it's pretty much impossible because of the way that the special categories of data regime is designed in data protection law. And there are really, really good reasons to ban collecting such data. For instance, I know it's a Godwin, but it is true that the Nazis had it easier to hunt for Jews in the Netherlands because they could use the IBM machines of Amsterdam to just make a list of all the Jews in the city. And after the Second World War, we stopped collecting people's ethnicity and religion. So there are really good reasons not to collect it. And so far, like Marvin said, one day while brainstorming, we say, no, there should be an exception. The next day we say, no, there shouldn't be, it's horrible. And therefore, for the moment, we decided we're going to map out the arguments. Perhaps at some point we start converging on one opinion, but for the moment, not yet, because depending on our mood and perhaps the weather, etc., one day we argue one way, one day we argue the other way.
Thank you, Marvin, Antonio, and Frederick. Frederick, a few years ago, I worked on a project funded by the European Commission, which was looking at data protection law and EU equality law and their interaction. And this question exactly came up. The question of can data be collected, yes or no, or is this, it can be collected and people are misinterpreting the law in the, so it's not as much of a barrier as people think. So that was a couple of years ago. I mean, it's all open access. If you're interested and you can't find it, send me an email and I'll hunt it out.
Oh, thank you. That is very generous offer.
Thank you.
Bye.
Yes, I would like to ask a small follow-up question to this. I see that there are other questions, but because this is connected to this discussion, could you say that the legal uncertainty, the problem of legal uncertainty, became bigger since the GDPR introduced this possibility of imposing enormous fines on an undertaking infringing the GDPR? And is that not the reason why legal certainty should exist with relation to such an important issue?
Marvin, want to have a go?
Yes, I totally agree, actually. While we were brainstorming about our paper, we also came to this point at some point, I remember, because the idea behind the GDPR is that states can also make laws to facilitate this data collection. And if you have 27 different laws that in every country regulate this data collection, then there is also a lot of legal uncertainty. And well, if you are a company that wants to check their AI against discrimination, then you want to be sure, because of these big fines, that your AI that it's allowed to collect this data. I mean, so yes, I totally agree. I don't know if Frederick has anything to add, but.
Yeah, good point. And it made me realize now that until the GDPR, perhaps the situation was much more cynical, namely, even if organizations thought, oh, data protection law probably prohibits this, we can collect it anyways because there's no real threat of enforcement or of fines. So perhaps that helps to explain why there's suddenly a new interest for the story, for the tension.
Okay, thank you. Pedro, you have a question.
Yes, it's more or less just building up on this, and very, very interesting. And from a very, very technical point of view, you would say, okay, personal information, name, picture, you know, sensitive data, right? But then in the medical sciences, you know, they have kind of a third thing, right? And this is the concept of biomarkers or whatever related to that can profile someone. You know, like, you know, DNA is not personal information per se, not like your name or your zip code, but it's a unique way to identify yourself, right? So then it's tricky. So they, in medical science, they consider that as a personal information. Good, great, right? But then if we come to the online world, there's a couple of things that are like DNA, right? So your browser history, your cookie settings, your advertisement settings, you know, and then if you put all those things together, well, it's a personal fingerprint and card, and can, you know, it's personal data, you know, even though it's not your name or your ethnicity or anything, right? So then the question would be like, you know, a company would argue, I'm not storing personal information, I'm not processing personal information, but they're inferring personal information, right? So then is where I'm not sure if GDPR is equipped to do these kind of things. So I don't know if the new kind of EU Digital Act, or also looking at the California homologous to the GDPR. So, you know, and then do you see any clarity on this distinction, Marvin, Frederick, perhaps? Yeah.
Frederick, yeah.
It's a good point. Like, at what point becomes data about an individual? Because at what point does it become personal data? It was mostly relevant until the GDPR was adopted, because the GDPR, the personal data definition, is on purpose defined so broadly that even online tracking companies now admit that they are dealing with personal data. Like, until the GDPR, the DoubleClick and Google and all the companies dealing with cookie profiles said, we're not collecting personal data. Since the GDPR, they admit that they collect personal data, even though they don't have names. But now they try other arguments, mostly saying we don't need consent because of blah, blah, blah. So at some point, I agree with you, there could still be doubt, but you can basically summarize the current personal data definition that any file about any data about an individual, with a name attached or not, with a zip code attached or not, is personal data. That is, yeah, so.
Yeah. It comes down then again to the interpretation, and, you know, depending on the mood of others, you know. Yeah, I think it's an ongoing discussion, and it's quite exciting also. Like, you know, from also, you know, computer scientists, data scientists, we are also trying to understand, you know, and that's awesome. I think that's a good synergy here.
Yeah, that's fun with different disciplines talking together.
Yeah. Mm-hmm. And I have a question also for Antonio, if I may.
Yes, sure. Go ahead.
Yeah. So a little bit also coming back to Fabrizio point, where, you know, if you're in the side of the seller on a private law point of view, if you go and put some disclosures on products, so, you know, like a disclosure like your price can be different than other consumers, whatever, because individualized personalization, algorithmic personalization whatsoever. I think, okay, it solves certain problems, but still, you know, you as consumer, you might want to know the whys, right? Also in terms of personal rights and these type of things. Like, okay, I might have a different price, but why though, right? So we see you know, in some platforms like Google, you can already see, you know, the Google profile, advertisement settings, and then you can see, you know, the characteristics that Google is telling you, I'm basing your recommendations based on these characteristics. Okay, good. But also things like, well, even Netflix would tell you, I recommend you this movie because you watch this other one. So now some platforms, they are saying, you know, I'm gonna give you this differential treatment because of this, right? Good. But then in a product, in a price, if I'm a Skyscanner, for example, and I tell you, and you get a higher price of the flight because you've been in this platform 30 minutes. It's like I'm gonna be pissed, So it's like, is that even feasible in a more releasing disclosures point of view in e-commerce? What do you think, Antonio?
So thank you so much, Pedro. This goes actually to a topic that I didn't have the chance to touch in the presentation, which is the problem with all, let's say, debate on the interpretability or explainability, let's say, of personalized practice. I see your point about trying to have some major determinants for personalization. I'm not a data scientist, so please forgive me if I'm not like super specific about that. But for example, I have the chance to analyze a little bit the ad archives that Facebook has, that you were mentioning, that are allegedly providing consumers information regarding the whys of some advertisements being disclosed to them. And I have to be honest, and I'd love actually to have your point of view on that. I was a bit unsatisfied with them because I thought what I saw actually was that the only information that I was able to find were about demographics. So I could have like very general information regarding the age range, the location and stuff like that, or of course the gender and stuff like that. But actually I was not provided with any meaningful information. And that's why I argue in favor of an ex post remedy, so not an ex ante one, because focusing on that actually provides me some demographics that I'm, as a consumer, and I mean, I think that we are all pretty sophisticated consumers here. I was not even able to infer how those demographics were related to the outcome or advertisements that were shown. I mean, in some cases, the connection is more straightforward than others. But on the other side, I have this feeling that the inference that is made is not actually from the demographics that is shown to me, but by some mediating factors that are actually behind those demographics. That's why I'm critical about an ex-ante evaluation of what information you should actually provide.
Yeah, exactly. So these proxies more or less behind it. So, and I see, Frederick, that you have something in mind going on. I don't know if you want to comment on it or not.
I just agreed with your remarks about the proxy, yeah. And I recognize the complaint that Facebook ad repositories don't give as much information as we would hope.
Yeah, that's great. Yeah. All right.
Happy, Pedro, with the answers?
Yeah, also. Yeah. Exactly.
I have a follow-up question for Frederick and Marvin regarding the aspect that you mentioned about legal certainty related to fines and actually the wide margin of appreciation that is in fines, let's say, in the power to provide fines. Now, the problem is that, I mean, I think at least that there is a clear reason, a straightforward reason for that, which is the huge power disparity and also economic disparity in market actors operating in the data market. And that could be like a preliminary reason to say, okay, I need to have a wide margin of appreciation to give fines because I have different amount and significant amount of power and economic power. Now, the problem is, and this is a question, do you think, and this is, of course, a little bit provocative, I have to be honest, do you think that even if we argued a lot for that, it makes sense to have a unitary regulation when such magnitude in the market power is present? Or should we argue in favor of a more multi-layered regulation, especially for fines, in which we can actually provide more legal certainty regarding, for example, the market sector in which the market power in which a company is finding itself in, rather than a general provision?
I'm sorry, I don't fully understand the question. If it's so, it's the GDPR fines, right?
Yes.
Yeah, they were like introduced because everybody ignored the old rules, and also because in 2012, when the first GDPR proposal was presented, it was already clear that that the big Silicon Valley companies are so big that you need insane fines basically to make them take you seriously. But what did you say about?
I totally agree with your point. I mean, that's definitely. But the problem is that on one side we have like the big Silicon Valley companies, and on the other side we have minor or smaller companies which are nevertheless involved in these forms of activity. And let's say, I think that the legal uncertainty that Caroline was mentioning about also comes from the fact that there is this huge margin of appreciation in fines.
Oh, I get it.
Yeah, I hope that I made myself more clear.
Now I get it. Yeah, but
it's not really a problem. I was just wondering about that.
I think with case law it will become slowly more clear. What there are already like 2 levels of fines in the GDPR, like 2 different maximums for different rules that you breach. So that gives some guidance, and it is still very young for legal terms. A law that is in place for 2 years, 3 almost now, but in legal terms that's young. I mean, now in criminal law we know kind of which type of murders gets you life and which types of murders get you life plus an insane, how do you say that? An asylum for mental help. So I suspect that within a few years, or with more years and more case law, it will become more clear. But I'm not at all a specialist on legal certainty around punishment.
Thank you.
Well, actually, my question was more about the legal uncertainty with regard to the substantive question. The fact that it can be argued that under the existing privacy rules, you can collect the data. It can be argued, is that enough for undertakings to work with?
No, but because even Marvin and I, after studying a lot, and Lisa also said the same, in this aspect, the rules didn't really change. And well, Marvin and I didn't finish our research yet, but Lisa already wrote on it, and there's clear ambiguity. So there's clear a need to decide on some policy, but like policymakers, Marvin and I don't know what the right policy should be yet.
And that is possibly also the reason why the rules are vague, because the legislators also found it delicate to adopt a clear rule.
Correct. And I think there's a second reason, that within the legal discipline, non-discrimination scholars and data protection scholars tend to work in different buildings, go to their own conferences, read their own journals, because non-discrimination law tends to come from a human rights or immigration law tradition. And they are typically at a human rights institute at a university. And in many universities, that actually means a different building. And data protection scholarship tends to come from the law and technology institutes. Like me, I've always worked at law and technology institutes, and I never studied non-discrimination law. I needed a Marie Curie grant and a year without teaching to teach myself non-discrimination law. So I suspect that like the data protection scholars didn't really foresee the problems. And vice versa with the non-discrimination scholars, we tend not to understand each other's disciplines, sub-disciplines, because both non-discrimination law and data protection law became so specialized.
Yeah. Okay, good. Frederik, you also...
a question too. Well, I don't want to talk too much, but could I ask a question to Yingxi Liu?
Yes, that was exactly what I was going to say.
Hi. The super important topic. discrimination in online advertising. I was wondering, do you have a rough idea about your research question? And do you have a rough idea in what discipline should I place you? Are you a computer scientist or a lawyer?
I'm a lawyer, and now I'm a PhD candidate in law. So my research topic is gender bias in AI. Because this is my first year, so I'm trying to decide which type of AI I will research more. It's about different type AI. I need to examine the different type of law, or maybe different type of solution, like this advertising. Maybe it's about the employment law in the human rights. But if about my another topic is like social credit algorithm. It's very famous in China because we have Alibaba, and we gave everyone a social credit score. We scoring everyone, but we don't know how to the algorithm, how to score everyone. And the company side, or maybe we will consider about your social circle, but it's ridiculous because the company said, oh, if you have the friend who like to play the computer games, you will get a lower social credit score. So yes, but for now, I didn't decide which type of AI I will focus. So
thank you. And are you going to focus on law in Europe or in China?
I want to do a comparative study. Europe and UK is the first focus, and the second is the China.
Super interesting. Okay, good luck. I can't wait to read your paper.
Thank you. I wish I can.
Yeah, we have many computer scientists here. Anybody who could advise her on what kind of AI she should look into?
I guess it has to be more like use cases, right? So that's what you should focus on, and not necessarily the technology behind. And the technology behind, I literally mean, some people will say, oh, deep learning, oh, NLP, or what, you know. And then if you start from there, you might go nowhere, right? So you start from use cases, right? Like, is that recommender systems for advertisement, or recommender system in a search engine, or, you know, so use cases, particular use cases in platforms, and you start from there, not from the technology.
Yes, thank you. Actually, I already learned how the AI work, but in the general way. So yes, I need to study more.
Also, as you said, your focus is actually China and Europe and UK, but just for, let's say, get a complete overview of the topic, also for getting some inspiration, maybe you might, if you want to go towards the credit score,
yeah,
you might want to see the literature on the FICO score, the American Creditworthiness Assessment Score, which is, I think, a good example. There is pretty extensive research on that, as a system that was traditionally linear, and it was actually pretty transparent when it was based on ponderated factors, and these gradually embraced more sophisticated, also with regards to soft data forms of elaborating creditworthiness assessment. So that might be a strand of literature that you might want to read, just to get a wider glimpse on the topic and try to figure out how to address that.
Okay, thank you for your advice.
Just a question, Liu. Is it credit in terms of financial credit,
Yes.
getting a loan? That's you are talking about, or is it the social credit system that is typical, that has been recently introduced in China?
Yes, in China, the social credit is not just include. It's not just about the financial. It's about what kind of service you can enjoy in the daily life. For example, if you have a very high social credit, you can use the shared bicycle without any pay. Yes, and maybe you have a higher social credit, you can get a higher loan from the bank. You can get more money and with very low interest. This is the problem. Even if you have a higher social credit, I want to apply for the UK visa, and I don't need to offer any certificate of my money, property. I don't need that. I don't need that kind of paper. Certificate paper to prove I don't want to, I have money or I'm not. Yes, so it's used in the several ways. So it's very important to every Chinese people.
Yeah, and if I understand it correctly, you said that at this moment, it is unclear which criteria the state is using to determine your credit score.
Yes, they said the company side they have they will consider 5 parts. One is your income. The second one is the how your something like which time you didn't pay the law, which time you paid later. This is the second part. The 3 part like when you buy something online. What kind of thing you usually to buy? They said if you usually to buy some materials about the baby, it means you have a high responsibility. So we will give you high social credit. And I don't remember the fourth part. I remember the last one is about your social circle. The algorithm will detect your social circle.
And what do you mean by the company side?
We have a big company, Alibaba. You know that? Yes. So this app created by Alibaba, but everyone has to use that. If you don't use that, you can't enjoy the service in the daily life.
Yeah, but the thing I am a bit confused about still is how does this scoring by Alibaba relate to the social credit system imposed by the state? Is it 2 different things or are they linked?
Links.
They are linked.
It's not different things. It's just in the Alibaba's app, you can check your social credit scoring. Yes, and the higher score is like 700 score. Great.
Yeah.
It's a higher score, and you can enjoy any special service in the daily life. Everyone admits that. I know why you feel confused. You mean it's Alibaba gave me the score. Why the other people will admit that will give me the special service?
Yeah, indeed. Yeah.
China works like this.
Okay.
I will type this kind of app on the chat and you will know more.
Yeah, very interesting. Yeah. Good. Any questions? Frederick, yeah. You're muted, Frederick. Yeah, okay.
A follow-up question to Yingxi Liu.
Yes.
Do you have an idea what the general opinion of the general public is in China about social credit system? Are they generally happy because it solves problems, or are they generally critical because it entails so much data collection, or is it?
You mean the public? You mean the government or the people?
The people.
The people. Chinese people don't think about that. Nobody think. And the government is happy because Alibaba may give our data, we share our data with government.
Yeah.
Yes, even someone sued in the law, in the court, and if he lost and he doesn't want to pay the money, and the court will ask Alibaba to check his money or his address or everything, and give something like a court paper, court file to that address. So the government is happy. And the people, I think the public, for this moment, the public is happy too, because if Alibaba doesn't do that, we can't enjoy this service. For example, the Alibaba talked to the like UK iceberg, I don't know how to say, like a UK government, like even before the Chinese people apply for the UK visa, we have to give proof of our poverty. We have to put the money in the bank for 3 months. We can't use that money, and then we can get the proof, and then we apply for our visa. It's very difficult, right?
Yes.
But for now, because Alibaba talked to the UK, so we don't use that. Okay,
yes,
so
there's advantages for the
Alibaba side, we want to be a guarantor for this kind of people because they have high social credit. We want to be the guarantor.
Yeah.
This is problem.
Okay, good. Very interesting. I think that we should wrap up here. And I want to thank all the participants, all the speakers, all the participants who asked questions in particular for their involvement in this conference. And well, I hope that we will have other opportunities to share ideas because I really like this a lot. I will give the floor to Pedro now to add some concluding words.
Yes, only left to literally thank you all. It was really fantastic 2 days. We really hope that this is just a starting point for many collaborations and many more events like this. So right now we see that there is a lot of overlapping on not only in our fields, like like in this side of the world, you would see things like marketing and data science coming together. But then also, Frederick, you mentioned, data protection law and consumer law, they're starting to merge together. But then and all those guys now started to mention one thing that is all these things that we are actually discussing. And sometimes we are, we might feel uncomfortable because it's not our domain, but we are coming into an area of interdisciplinary research. So we have to actually start to feel comfortable with this type of setups. So we're really happy, very thankful for this, and hopefully see you guys next time. Thank you very much.